My lord, I beg to mention item number 44 of today's hearing list on behalf of the respondents' counsel, Mr. S. Sahu. My lord, I have taken the consent from the other side also.
All right. Item 44.
Next week, my lord. Item 44 of hearing list, today's hearing list.
All right. Item 44 at the request of counsel, prayer made on behalf of. There's no one else with you?
I am requesting on behalf of Mr. Sahu,
All
my
right.
lord.
On a request
Because
made
for
on behalf
personal
of Mr.
difficulty,
Sahu
he is away.
on personal ground,
Do not declare
matter
my lord.
stands deferred to be listed after 2 weeks.
I am obliged, my lord.
Item number 42, Lordship.
Hmm.
Lordship, we are seeking for, I'm seeking for adjournment, Lordship, today.
No, you've been praying for adjournment. Either
Lordship,
withdraw the
at
petition.
the last date, Lordship, on after view, Lordship. I'm not.
What is this after view, after this, after that? They've been giving you at least 10, 15 adjournment. For what purpose?
Lordship,
And it is
actually,
hearing.
I have to give a reply also, Lordship.
You want to give a reply, you want to
Lordship,
file a reply, you don't want to file, you do what you make up your mind and do something. Why get the matter listed?
No, Lordship, because Lordship, after view, it will be clear, Lordship.
We are not fixing a date, we are adjourning it. You make a mention whenever you think you are ready to hear the matter. Item 42 at the request of counsel, Mr. P. Sharma, matter stands deferred to be listed after 3 weeks.
May it be, Your Lordship. With regard to item number 28, Lordship, we filed a affidavit in reply yesterday that may be called for, Your Lordship.
28.
Yes, Your Lordship.
When did you file it?
Yesterday, Your Lordship.
Then let it come next week.
Let it be tagged, Your Lordship.
Tag?
Let it be called for, Your Lordship.
Yes, it will be called for, it will be listed next week. Why file an affidavit yesterday and get it listed today?
Already the matter is listed today, Your Lordship.
There is listed all right, but the affidavit should have been filed earlier.
Yes, Your Lordship. That's difficulty on my part, Your Lordship.
Let it come next week along with the affidavit.
As Your Lordship, please.
Item-
There's an interim order, Your Lordship.
Item 28 be listed on 2nd of, this is for what? Admission hearing,
Admission hearing, Your Lordship.
2nd of April. Along with the affidavit in reply,
Reply, Your Lordship.
stated to have been filed by the counsel for the petitioner, Mr. A. Das. Registry will press out the affidavit and place it before the court on the next date fixed. It's accordingly.
Much obliged, Your Lordship.
May it please, Your Lordship.
Yeah.
Lordship, we have filed an additional affidavit in supplementary item 51, Lordship, which is furthered before Your Lordship today. Lordship, the record may be called for, Lordship.
Let it be next week or after 1 week.
Then it is okay.
51.
Supplementary item 51, Lordship.
It is a part of the series.
Yes, Lordship.
Why did you file it yesterday?
Day before yesterday, we have filed, Lordship.
We don't know. You wait. We'll not call for it now.
Lordship.
Let us
In item 20, there's an interim order, Your Lordship.
28 interim order to be extended until further order.
Much obliged, Your Lordship.
May I please, my lord, with regards to item number 3, my lord, today, during the course of the day, we are going to file our response, my lord, and copy will be served to the opposite counsel during the course of the day, my lord. Item number 3, my lord.
Item 3 at the request of Mr. H. Porwa,
My lord.
Counsel for Finance and Taxation. Matter stands deferred to be listed after 2 weeks. As it is submitted that the reply affidavit, the counter affidavit is being filed in the course of the day. Counsel for appearing for the petitioner, Mr.
H. Ali.
H. Ali, does not object. The prayer made. Please record it.
Oblige, my lord.
Please, the Lordship. Can it be taken up after some time, Lordship?
Hmm?
Mr. Soma is legs on court number 2. Can it be taken after some time, Lordship?
So review for what?
Well, there was an order for considering the petitioner's claim for VRS and an undertaking for VRS, voluntary retirement. And a statement was recorded made by the petitioner's counsel that, my lord, he will not claim for any benefit, my lord, if the VRS is granted by the government.
Which order you are seeking review?
Lordship, order dated 10/5/2019, Lordship.
So What is his submission? What
Lordship,
is his
para
ground?
10, my lord. He's agreed by the statement made in para 10.
Para 10.
Yes, my lord. Page
Hmm.
47.
Yes.
However, it has been contended on behalf of the petitioner that since he has sought resignation, he is not seeking any benefit from the state. And as such, the question of the so-called unauthorized period of absence is irrelevant.
This is what is sought to be reviewed.
It is sought to be reviewed. More
Why?
particularly, my lord, after, my lord, we have accepted the VRS on this particular condition. Now, my lord, if it is reviewed, we'll have to review the VRS also, my lord. We may cancel it, my lord. That is the ground, my lord, we have taken. Otherwise, because the review was filed much after the, my lord, decision was taken.
What is the ground for review?
Ground is, my lord, that without any authority, that statement was made.
That is not a ground for review.
Yes, sir. And, my lord,
That is not a ground for review.
Let him come, Lord.
No, we are not stopping him from coming. He is not here. Huh? After some time.
Okay.
All right.
or, my lord, next week, because some series is again, my lord, is there.
What is next?
My lord, next
Series.
week, yes,
Yeah.
I will have to,
Yeah.
if possible, my lord. Because otherwise, issue is short, my lord, only on that point.
All right. Next week, please. Next week,
My
list
lord.
on first
First, my lord.
1st of April.
My lord.
The request made by counsel for the petitioner, MS
K. Borpujari.
K. Borpuzari
Lordship.
and Mr. D. Gogoi.
My lord. Here, help.
You are now additional AG.
No.
Additional AG Assam.
No.
Appearing for the respondent does not object to the prayer made. Please. First.
Obliged.
Obliged.
Here, your lordship, we have written to them to as a reminder to send to come and swear this affidavit of opposition on 5th. Till date, they have not yet come. So some 1 week time is granted, your lordship.
MS S. Seal counsel for the S. Kanungo appears for the petitioner, Mr. D. Boran. For the respondent who submits that the instructions are not yet complete. He prays for further time. Please. After 2 weeks,
Lordship, a date may be fixed, otherwise it will come.
by 3 weeks, it's on 21st.
Highly
Deeply
obliged, your lordship.
Sorry, my lord.
Hmm?
Like, on that day, I could not.
Huh?
On last occasion, I could not my lord, base my argument, my lord.
Yes.
I will argue on, my lord, item 6, my lord.
Item 6.
Page 54, my lord.
54.
54, my lord. Second paragraph, my lord. May I read, my lord? May I read, my lord? Something. The petitioner in this case is holding disability certificate issued by the competent authority under Department of Social Justice and Empowerment Assam, indicating the degree and nature of his disability. According to the certificate held by him, the petitioner meets the benchmark disability criteria of 40% disability, thus making him eligible to seek government employment as candidate belonging to person with disability PWD category. As such, on the strength of this certificate, the petitioner had applied for and had taken part in the recruitment process initiated by the government department for filling a number of grade 3 posts. It should be grade 3. However, after selection process was over, the petitioner has been asked to appear before a specially constituted medical board so as to verify, reassess the nature and extent of the disability suffered by him. Agreed thereby, the present petition has been filed inter alia, contending that since the petitioner is holding a disability certificate issued by the competent authority, there was no further requirement under law or any legal justification to subject the petitioner to further scrutiny by another medical board, as has been done in this case, my lord. Next case, my lord. Taking note of the grievance expressed by the petitioner, this court had directed the Learned Standing Council Health Department to obtain instruction today when the matter was called up for submits that the role of the Health and Laboratory Department in this case is only to the extent of constituting a special medical board so as to assess the nature and extent of the disability suffered by the candidate on the request of the nodal department, that is the Department of Social Justice and Empowerment. Therefore, the Health Department does not have any independent stand in the matter, my lord. If further submits that on such verification, the disability of some candidate have found less than benchmark disability, when however submits that the outcome of the assessment, my lord, constitutional medical board has already been forwarded to the social justice. Accordingly, they have the honorable court last paragraph 56, my last paragraph. As such, without expressing any opinion on the stand of the Department of Council or finding the observation of the medical board, this return is being disposed of, directing the respondent to communicate the decision of the authority pertaining to the disability status and his claim for avoidance in the post within a force of the duration of this liberty is granted to the petitioner to assign the decision to the medical and or the Department of Social Justice and Empowerment by filing predicate petition. My lord, I will argue, my lord, on the arbitrary decision and the exercise, my lord, and the action, inaction, my lord, of the.
What are your prayers here? Who's for the respondent? Social Justice Department, who's there? You're ready for hearing? Your pleadings are complete?
Pleadings of Lordship, we don't have role in this case.
Huh?
We don't have role in this
You don't
case.
have. Who has health?
Health will,
Who's for the health?
medical code will be the
Yes, Mr. Chaudhary, where is your colleague? Please inform me. Yes,
Before I go to relevant provision, my lord, I point out
yes.
Lordship. Certain documents were called for on the last day of it. Can I have a week more time, Lordship? I'm here to discuss those documents.
No. What documents we call for?
Lordship, the reports based on which these certificates were issued. The certificate at page 36 and Lordship at page 52.
Let us hear him first.
Yes, Lord.
Yes.
my lord, can I see page, my lord, 47, my lord. The petitioner on merit, my lord, he has been selected in 4 posts in 4 different, my lord, department. 47 page, he has been selected number 1 co-person department, home political department, panchayat rural department, on water resources, on merit, my lord. And if you lordship kindly see, he appeared as a EWS category, my lord. 43, page 43, economically weaker section, my lord. And my lord, if you lordship kindly see page 37, he was appeared in the examination on holding this certificate. It was issued 28/1/2021, my lord. It was valid up to 28/2/2024, my lord. And he has given in the certificate, it appears 40%, my lord. Then your lordship kindly see page 39, my lord. On renewal, my lord. On renewal, my lord, he has given the 80%, my lord. But my lord, as per the honorable court's direction, my lord, he has been given 30%, my lord. Page 58, my lord. There is no issue. Percentage is not in issue, my lord. Just I am pointing out the action of the respondent authority, my lord. Page 58.
Which order? 10-1.
Yes, my
Order dated 10-1. No, honor.
10-1, my lord.
Court
Pursuant to the
order 10.
10-1, my lord, the status I have given is the status blind and low vision, my lord. And my lord, percentage is for 30%, my lord. But Percentage is not issue, my lord, as per the policy in the statute, my lord.
Yes. So pursuant to this, there was the results furnished to you,
Yes, my.
which
My lord,
showed you are holding.
I am also, I am a disabled, my lord,
30%.
30%. I am, but admittedly, I am a PWD, my lord.
But you don't have the benchmark disability.
Yes, my lord. And my lord, kindly see the relevant provision of the act, my lord.
Disability Act.
16 or 95 to this. And earlier, I have given a list of judgment, my lord.
Is there in the first file.
Yes, sir.
95, 2016.
2016, my lord.
But click it, करा के देखिए. Final.
No, Section 33, my lord. Section 30, may I read, my lord?
Hmm.
My lord, the appropriate government shall identify posts in the establishment which can be held by respective category of person with benchmark disabilities in respect of the vacancies reserved in accordance with the provision of Section 34, my lord. Suppose constitute an expert committee with representative of person with benchmark disability for identification of such post and answer review, my lord. Section 34, my lord, reservation. Every appropriate government shall appoint in every government establishment not less than 4% of the total number of vacancies in the cadre strength in each group of posts meant to be filled with person with benchmark disability, of which 1% each shall be reserved for person with benchmark disability under clause 1, under clause A, B, and C, and 1% for person with benchmark disabilities under clause D and E, namely so and so, my lord. E. Multiple disabilities from amongst person under clause A to D, including D blindness, in the post identified for each disabilities, my lord.
Hmm.
Provided that the reservation in promotion shall be in accordance with such instructions, then, my lord, provided further that the appropriate government in consultation with the seat commissioner or the state commissioner, as the case may be, may, having regard to the type of work carried out in government establishment, by notification and subject to such condition, if any, as may be specified in such notification, exempt any government establishment for the post for the provision of this section. Then subsection 2, my lord. where in any recruitment year any vacancy cannot be filled up due to non-availability of a suitable person with benchmark disability, or for any other sufficient reason, such vacancy shall be carried forward in the succeeding recruitment year. And if in the succeeding recruitment year also suitable person with benchmark disability is not available, it may be first filled up by interchange among the 5 categories, and only when there is no person with benchmark disabilities available for the post in that year, the employer shall fill up the vacancy by appointment of a person other than a person with disability. Then provided that if the nature of vacancy in an establishment is such that a given category of person cannot be employed, the vacancy may be interchanged among the 5 categories with prior approval of the appropriate government. The appropriate government may, by notification, provide for such relaxation of upper age limit for employment of person with benchmark disabilities as it thinks fit. Then, my lord, section 35, my lord. Incentive to the employee in private sector, the appropriate government and the local authorities shall, within limit of their economic capacity and development, provide incentive to employer in private sector to ensure that at least 5% of their workforce is composed of person with benchmark disability. Then your lordship kindly see rule, my lord, rule 11. My lord.
So your grievance is that once a certificate is issued, it cannot be reissued, reassessed.
Reassess, and my lord, the reservation for the PWD and benchmark, the concept of benchmark has been introduced in the act, my lord, giving a benchmark for the appropriate government to fill up not less than 4%, my lord. That is the benchmark for the PWD.
No, you are here for what purpose? You are here because the benchmark of percentage of disability which was given by the authority
Yes.
has not been accepted by the state government.
Yes.
That is your grievance.
Yes.
So
And my lord, the basis of their decision, my lord, reassessment, my lord.
is that notification?
My lord.
There is a notification.
Yes, there is a notification.
Which
Oh,
you are
my lord.
putting to challenge.
Yes, the basis.
You show us that in terms of the provisions of the act or any judgment, this notification could not have been issued.
Yes,
This
my
is
lord. I'll come.
the area of argument that you should do instead of trying to take us through the various sections of the act.
And even, my lord, the certificate, because the certificate is issue, my lord, the reservation vacancy, reservation for the PWD only, and
Whether it is for PWD or not PWD is a different aspect.
Yes.
You are claiming as process for selection in respect of posts shown to be reserved for PWD.
Yes.
Provided you have the benchmark disability, which is 40%.
Yes.
According to you, you have documents to show that 40, 80, 90, whatever percentage has been given.
Yes.
But subsequent, after you being successful in the test,
yes,
you are subjected to medical examination and they found you to be below the benchmark.
yes, yes,
So the ground that you are trying to urge before the court is this cannot be done.
yes,
Government has done it on the basis of a notification.
yes.
So you are challenging the notification. So
My lord, the basis, my lord. On what basis they have done this?
exactly.
Yes, my lord.
So why are you before the court
Yes, for that, my lord.
for that? So
Yes.
argue on that.
Yes, my lord. The notification,
You have already been given an opportunity. This is the
Yes.
second one.
notification page 59,
Of
one. Of my writ petition,
writ petition. Okay. 59.
15.
Yes.
Page 15.
This is the notification.
Yes, my lord. OM, my lord.
OM. Yes.
The basis of their, my lord, the power which has been exercised, my lord, that is, my lord, clause 4, my lord. Before clause 4, I may read, my lord, just quantum of reservation, my lord. 4% of the total number of posts to be filled up by direct recruitment, 4% has been reserved, my lord. Then, my lord, clause 4, my lord, kindly see. In the category of posts which are identified suitable for person with benchmark disabilities, a person with benchmark disability cannot be denied the right to compete for appointment by direct recruitment promotion against an unreserved post. Thus, a person with benchmark disability can be appointed by direct recruitment promotion against post not specifically reserved for person with benchmark disability, provided that the post is identified suitable for person with benchmark disability of the relevant category. Then clause 4.2, my lord. Person with benchmark disabilities selected without relaxed standard along with other candidate will not be adjusted against the reserved share of post. The reserve post will be filled up separately from among the eligible candidates with benchmark disabilities, which will thus comprise of candidates with benchmark disabilities who are lower in merit than the last candidate in merit list, but otherwise found suitable for appointment if necessary by relaxed standard, my lord.
Yes, then
And my lord, also this reservation, my lord, benchmark reservation has been, they have been, my lord, if you lordship kindly clause 9, my lord, clause 9. Under clause 9, my lord, they say that this reservation for benchmark, my lord, it's horizontal, my lord. That is, my lord, 9.2, my lord.
Yes.
Reservation for person with benchmark disability is horizontal, my lord. It's not a vertical reservation. If your lordship, then, my lord, if it is a horizontal reservation under Article 16(1), my lord, then, my lord, the here, my lord, 4.2, my lord, what they have stated, my lord, person with benchmark disability selected without relaxed standard along with other candidate will not be adjusted against the reserved share of post. The reserve post will be filled up separately from among the eligible candidates with benchmark disability, which will thus comprise of candidates with benchmark disability who are lower in merit than the last candidate in merit list, but otherwise found suitable for appointment if necessary. But the lower in merit, my lord, the honorable appeals already held that the person with benchmark disability, my lord, has to, my lord, secure marks the cutoff, my lord, who is under which he has appeared, my lord. If I am the economic weaker section, my lord, I has to, my lord, secure the
no, but the bottom line is you must have benchmark disability.
yes.
You don't have benchmark disability as found by the state.
That's why, my lord. Then, my lord, that's why I am relying on this relevant provision. Under this act and rule, my lord, they cannot, my lord. This is not subject to any notification, my lord.
Where is it? Where is the bar?
Yes.
Where is the bar?
Yes, my lord. Bar. I am coming, my lord. Therefore, I am in the rule.
We have given you enough time to come. You are still coming.
My
You
lord,
have to reach that point.
yes, my lord.
Show us. What?
Before I certificate rule, my lord, I just clarify, my lord, the
No. Don't clarify. Show us where is the bar.
yes, my lord.
Where is the bar that the state can issue a notification under the act or the rules?
Yes. Rule 17 to 20, my lord.
17.
To 20.
Yes.
Page 54, my lord, of that, my lord.
Huh?
Page 54 of that book, my lord.
54.
Page 54.
Yes.
My lord, application for disability, section 7 says application for certificate, my lord. Any person with special disability may apply for means of my lord. Then, my lord, 18, rule 18, my lord. Issue certificate of disability. On receipt of an application under Rule 17, the medical authority or any other notified competent authority shall verify the information as provided by the applicant and shall assess the disability in terms of the relevant guidelines issued by the central government, and after satisfying himself that the applicant is a person with disability, issue a certificate of disability in his favor in the form so. Then clause 2, the medical authority shall issue certificate of disability within a month from the date of receipt of the application. The medical authority shall, after due examination, issue a permanent certificate of disability in cases where there are no chances of variation of disability over time in the degree of disability. Issue a certificate of disability indicating the period of validity in the cases where there is a chance of variation of the over time in the degree of disability. If an applicant is found to be ineligible for issue of certificate of disability, the medical authority shall convey the reason to him in writing under form so and so, for a period of 1 month from the date received. The state government and union territory shall ensure that the certificate of disability is granted on online platform from such date as may be notified by the central government. Then Rule 19, my lord. Certificate issued under Rule 18 of the generally valid for all purposes. A person to whom the certificate issued under Rule 18 shall be entitled to apply for facilities, concessions, and benefit admissible for person with disabilities under a scheme of the government and of the non-government organization funded by the government. Then 20, my lord. The validity of certificate of disability issued under the repealed act. The certificate of disability issued under the Person with Disabilities Act 1995 shall continue to be valid after commencement of the Act for the period specified therein. For a moment, my lord, kindly see the 1995 Act, my lord.
Yes.
My lord, Rule 6, my lord. This is the corresponding provision, my lord. Rule 6
Rule 6 of
of Person with Disability Equal Opportunity Rules 1996, page 31, 95 Act, page 31.
yes.
Rule 5, my lord, issue of disability certificate, then 5 review provision, my lord. Then, my lord, 6, my lord. A certificate issued under Rule 4 shall render a person eligible to apply for facilities, concession, and benefit admissible under a scheme of government and of non-government organization funded by the government, subject to such conditions as may be specified in the relevant speak or instruction of government, etc., as the case may be made. If your lordship, my lord, the intention of the legislature, my lord, this subject, my lord, in the new rule, my lord, there is no such subject, my lord. And my lord, there I am saying, my lord, if you, my lord, kindly see Rule 11, my lord, 11 of the 2016 Act, my lord. Rule 11, kindly see, my lord.
Where is the medical authority defined?
Medical authority, my lord. My lord, if your lordship kindly see certifying authority, my lord.
39.
Certifying authority, E, my lord, 2E. Certifying authority means an authority designated under subsection 1 of section 57. And my lord, kindly see the person with disability and person with benchmark disability, my lord. Who is the person with benchmark disability, my lord? R, my lord, kindly see. Person with benchmark disability means a person with not less than 40% of a specified disability, where the specified disability has not been defined in measurable terms and includes a person with disability, my lord, PWD, where a specific disability has been defined in measurable terms as certified by the certifying authority, not by the medical authority, my lord. Certifying authority, my lord. Because, my lord, on earlier occasion, I have submitted, my lord, there is a shifting of the concept of disability, my lord, from the medical stigmatizing medical disability to a social model of disability, my lord. But by the OM, my lord, the government what has done, my lord, to wipe out the benchmark given by the Act, my lord, 4% has to appoint, my lord. To wipe that benchmark, my lord, they have classified the benchmark and the PWD, my lord, in violation of Article 14, my lord. And, my lord, we are, my lord, now, we are, my lord, arguing, my lord, on the medical disability, my lord, percentage. What kind of, my lord, having, my lord? My lord, this arbitrary action has been done.
Where is the bar? Where is the express bar?
Express bar,
That it cannot be reassessed.
express bar, my lord. If, my lord, I have submitted on the Bikash Kumar, my lord, once accepted, my lord, I have the holding a certificate issued by the authority, my lord.
The question is whether the state government is not entitled to verify whether the extent of disability or the disability certificate, moment it is given, they'll have to accept without any demand.
My lord,
Is that the mandate of the act? And
if even, my lord, I holding that certificate, my lord,
you're holding the certificate has to, is there an express bar that the certificate cannot be scrutinized once it is issued by the certified?
yes, it can be verified, my lord. It can be verified that not the contents, my lord.
Hmm.
What they have power, the verification.
From where are you saying all that?
They have exercised that power by the OM, my lord, clause 5, my lord.
No, no. The fact that it can be verified and not into the contents, from where are you making the submission?
And apart from, yes, my lord, but the reserve, my lord, the reservation in the employment.
Reservation will come later. First,
Yes.
tell us about the criteria. You'll have to first enter into the zone.
Yes.
Before you can lay a claim on the criteria, on the reservation.
Yes. But they can reassess, my lord. They can reassess, but they cannot, my lord, deny uh, on the basis that I am 30%. They cannot deny my.
This is the reassessment.
My lord, if I am not holding a benchmark digit, they cannot deny, my lord, because the reservation for benchmark, my lord, for vacancy based, not post based, my lord, acts as a
All right, but you have to satisfy that benchmark disability.
no, my lord. Kindly see the rule. Therefore, I am saying, my lord, rule 11. Kindly see, my lord. Rule 11. What is the reservation, my lord? Rule 11.
72.
Yes, my lord. Rule 11, my lord. Page 52, my lord.
Yes.
Computation of vacancies, my lord. For the purpose of computation of vacancies, 4% of the total number of vacancies, including vacancies arising in the identified and non-identified posts in the category each
That you
group.
can lay a claim provided you satisfy that you.
Then, my lord, kindly see, my lord, 4. The reservation for person with disabilities in accordance with the provisions of section 34
Yes.
shall be horizontal. The reservation 34, which says the reservation, my lord, in employment for the PWD, my lord, and the vacancies for persons with benchmark disability shall be maintained as a separate class, my lord. The vacancy, my lord, not the 4% vacancy they have to fill up, my lord. The reservation says section 34 for the PWD, my lord, and that my lord, if it is a horizontal reservation, the ceiling of 50% does not apply in horizontal, my lord. So, my lord, the reservation for the PWD, my lord, and they have one says that the lowest category, in Rekha Sharma's case, my lord, says that benchmark PWD, my lord, has to secure the cutoff marks of the, my lord, by the category under which he has applied, as I have applied for the EWS, my lord. Then, my lord, on merit I have been selected, my lord. Then can they, my lord, they deny my appointment, my lord, on the basis?
You see section 34.
Yes. Section 34. If your lordship, the section 34, this section has been drafted, my lord, after giving interpretation by the honorable court in a case, my lord. Then this was drafted, my lord. And although, my lord, draft rule was interpreted, my lord. If your lordship, for clarification, my lord, may I place that judgment, my lord?
First, let us read the section. What is the meaning of this section?
Yes.
What is the mandate of this section?
Yes. Section 34. every appropriate government shall appoint in every government establishment not less than 4% of the total number of vacancies in the cadastre each group of posts meant to be filled with personal measurement. This is the first part, my lord. And my lord, second part is of which, my lord. First part is reservation for PWD and 4% has to be appointed by the appropriate government, my lord.
Benchmark.
4% benchmark, my lord. But reservation, we appeared as a selection process as a PWD candidate.
Provided you satisfy the benchmark disability.
No, man.
This 1% is in the different category of that 4%.
That is the benchmark for that they have to work out, my lord. My lord. Then, my lord,
Is it your argument that benchmark reservation for benchmark is different, and anybody who is otherwise a disabled person with disability,
Yes.
not meeting the criteria of benchmark, they are also entitled to reservation. Is that correct?
my lord, even if my lord 4%, because my lord, even if my lord kindly see this, therefore
Yes or no? Is that the argument you're making?
yes, my lord, because there is
You
a
show us from section 34, that is the source of the reservation.
my lord
The
section.
mandate of section 34 prescribes that.
Therefore, my lord, section 2, my lord kindly see, suitable person, my lord. If my lord suitable person of my lord carried forward, if not suitable person of benchmark, then my lord
Carry forward is okay.
is different, my lord. Then also, my lord, in that my lord case, my lord, the only when there is no PWD, my lord, then they can appoint a person other than my lord.
These are, you are not before the court for this. Your question is that
Yes.
40% disability, there is a certificate, state government is not receiving that. They are going for a fresh assessment. It's okay.
But what happened, my lord? For the 4% disability to that, my lord, they have, my lord, deprived my right, my lord, equal opportunity, my lord. Because after, my lord, they have classified, my lord, what says, my lord, rule 11, my lord.
We are not finding merit in your case.
No, my lord, what's for the rule 11, my lord? My lord, and my lord, the denial of it is my right, my lord, the reasonable accommodation, my lord. Under the,
Reasonable, you are appearing for a selection process
yes,
pursuant to an advertisement. Advertisement has made it very clear, the benchmark disability.
yes.
You claim to satisfy the benchmark disability, you appear, then you are put up for medical or whatever examination, and you are found to be not in possession of
then
benchmark disability. That is
this is, my lord, therefore, my lord, I am citing, my lord, the lieutenant colonel, indirect discrimination, my lord.
what
The
indirect
arbitrariness, my lord, arbitrariness, my lord.
your claim will arise when you say that once a certificate is issued, it cannot be reassessed in terms of the provisions of the act or some authority
Yes, my
you
lord.
want to place
There-
rely.
My lord, therefore, my lord, the certificate issued under the, my lord, there is no subject, any condition, my lord. Under the rule, my lord, the certificate issued, my lord, and the earlier, my lord, my right accrued, my lord, I have been,
Where is the assessment made here?
my lord,
Where is the reassessment made?
there is a course. And my lord, kindly see the, my lord, the Rekha Sharma judgment, my lord, what they have stated, my lord. Rekha Sharma. Well, yes,
Who is
yes,
who is the appropriate authority here in granting you the status? Medical
certifying authority.
certifying authority.
Certifying authority. He is the appropriate authority.
Certifying authority is a medical authority under the Department of Empowerment,
Yes,
and the reassessing authority is also a medical authority. Under
but
the Department
under
of
the
Social
under the
Justice.
act, my lord, there is no such, there is no, my lord, the as per the provision, my lord, under the notification they have appointed a certifying authority under the joint director of that joint director of health services has, my lord, issued this certificate, my lord. Then if, my lord, that is not, they are not complying with that, my lord, certificate, my lord, then, my lord, only GMC can assess, and, my lord, he issued the certificate, my lord, issue a notification, my lord. Then why we are suffering, my lord? It is the notification as per the
You're-
notification.
You're suffering because you don't fulfill the benchmark criteria.
Then, my lord, I have holding two certificate, my lord. It may be changed in time, my lord. My lord, therefore, my lord, in indirect discrimination, my lord, this is
What is your disability?
low vision, my lord.
Visual,
Yes, my lord.
visual.
Yes.
So visual, unless you say that the disability is to such an extent that once assessed, there's no scope for improvement.
But my lord, the reservation, what my fault, my lord? I am a PWD, not, I am not appeared as a, my lord, kindly see, my lord. And I am not appeared as a benchmark, my lord. I am as a PWD appeared, my
The
lord.
PWD reservation is there in 34.
34.
Yes.
Yeah, that may be, my lord, because that may be, my lord, that reservation, that may be, my lord, there may be PWD selected on merit, my lord, 80% also.
You are not
If your lordship kindly see that is this judgment, my lord.
with the
My lord, the Rekha Sharma judgment, my lord. The benchmark is disability. I have secured mark, my lord, on EWC category, my lord.
that বিচারক রেখা শর্মা স্যার।
24/8 SCR 488.
সেইটো তেওঁলোকক দি দিয়ক বিচাৰি ল'ব তেওঁলোকক দি দিয়ক।
And my lord, it is a case of indirect discrimination. In the indirect discrimination, my lord, this neutral, facially neutral medical criteria, my lord, that is, my lord, the time is the factor to determine, my lord, arbitrariness.
Do you have an extra copy of the judgment?
Yes, yes.
Give it.
Sure, thank you.
Yes, tell them.
My lord, paragraph 9, my lord.
Just tell us what is the judgment about.
Yes, my lord, herein, my lord, a person, benchmark person, my lord, he applied for
Come to para 2, read para 2.
yes. The facts in nutshell are that the respondent High Court had issued advertisement of the direct recruitment of class 124 of civil judge as research under the certificate. The appellant Mr. Rekha Sharma, having 14 permanent disability in the relation with our eyes, had applied for said post. The appellant having locomotor disability, that is permanent physical impairment in the upper head limit, had also applied for said post. Both having appeared in the preliminary examination were declared not successful. As per result declared on Friendship, the cut-off marks in respect of every category mentioned in the advertisement were shown except the cut-off marks for the category person of benchmark disability. Being agreed by the state whether the applicant ultimately the cut-off mark has not been shown for the benchmark, therefore he has before the honorable apex court. My lord, then my lord, kindly see the advert which is the vacancy position like us, my lord, same, my lord. Paragraph 6, my lord, the advertisement has been shown, my lord. Person with benchmark disability out of 89 vacancies, 4 posts for person with benchmark disability, my lord. But in the our advertisement, there is no such, my lord, indication, my lord. Only they have subsequently, my lord, given the vacancy detail, my lord.
Yes,
Then, my lord, 9, my lord.
there are 9.
It is quite well settled that the horizontal reservation is of two types: compartmentalized horizontal reservation and overall horizontal reservation. The compartmentalized horizontal reservation is such wherein the proportionate vacancies are reserved in each vertical reserve category. However, in case of overall horizontal reservation, the reservation is provided in the total post advertised. Such reservation is not specific to each vertical category. As per advertisement is shown, so the vacancy in case of women candidates were classified, identified for each category, that is general, OBC, so and so. Whereas the person with benchmark disabilities no such vacancies were mentioned in the said category. Further, in three-tier process of examination scheme, the number of candidates to be admitted to the main examination were 15 times total number of vacancies category, and the candidates had to qualify themselves by securing minimum percentage of marks fixed for each of the categories in preliminary examination. Therefore, the person with benchmark disabilities falling under the overall horizontal reservation had to qualify for main examination by securing minimum cut-off marks fixed for the concerned category in which she had applied, my lord. Well, I have applied, my lord, EWS category, my lord. And on merit, I have been selected, my lord. But the OM, what says, my lord? The lowest category, they have classified, my lord, lowest in the merit list, my lord. That cannot be, my lord. Under what article, my lord? What power, my lord?
All right, yes, respondents. Anything to submit?
One thing is that also, as part of OM, clause 5 speaks about process re-verification and re-verification.
Question is, do you have the right to reassess a disability which has been issued by
The
the
right
certifying authority?
Right process, we have made one OM that gives us the something.
No, whether you have the power to make the OM under the Act and the rules, that is the question. From where do you derive the power? From which section, which part of the rules?
Lordship,
source the
the OM, the first paragraph, in pursuance to the right of person with disabilities act 2016, and in supersession of the earlier OM dated 19, the following instructions are issued regarding reservation of person with disability as specified disabilities as defined under 2R of the Act.
Do you have a copy of the petition with you? This is item number 6.
Yes, Sanjay Chauhan, yes.
Mustafa, sit.
If you come to section 49 of the Act, 16 Act.
Yes, sir, competent authority.
Competent authority. State government will appoint.
Yes.
Now, come to the certificate issued by the petitioner. Page number 39. Or page number 37.
Lordship.
These are certificates issued by the
Borpeta, Joint Director of Health Service, Borpeta.
competent authority.
Yes.
Now, come to the certificate, come to the medical document, finally. These certificates indicate there is 40%. Page number 37 indicates 40% is benchmark visibility.
Lordship.
And 39 shows 80% more than the benchmark.
Lordship.
Now come page number 58. This is by another authority which shows here 30%.
Lordship.
On what ground, firstly, variation has occurred?
Lordship.
Number 2, one, certificates are issued. Where was the occasion to go for a re-verification? Unless say that the certificates are incorrect, false.
Lordship, actually, recently I have gone through a judgment where it is said that it happens, Lordship, fraudulent can be happen in various, in getting the certificates.
We know fraudulent can be happened that
So that is the
forgery can take place, but the question is, in the facts of this case, was there any finding that fraudulent and false, which resulted in reassessment of the disability? There is no finding by the department.
There is no, Lordship, individual thing. It's a Lordship.
Has to be.
It's a general thing, Lordship.
No, not general. You can't keep on doing the degree of disability as per your business pencil. The Act very clear. Certifying authority will give you. And once the certificate is there, it is valid for all purposes.
Even in our affidavit, Lordship, we have said that the
Let
act
us-
is silent in regard to Lordship this.
Let us see your affidavit. Which
Yes.
paragraph?
Process. Lordship, kindly take Sanjay Chauhan matter.
Hmm?
Kindly take Sanjay Chauhan, Lordship, item number 4.
Yes.
Lordship, kindly see page number 67. In such circumstances. In such circumstances, the person who generally deserve and meet the threshold of 40% of benchmark disability stops their statutory right of reservation and are put to a disadvantageous situation of negative equality as candidates who are not genuinely deserving take away the benefits.
So
Which also a-
which circumstance? What circumstance? What are the circumstances? What you're asking? You see para 8.
Here also it is stated that as the right of the
No,
person.
no, see your paragraph 8. Last sentence.
Yes.
First paragraph. Please read it. State government.
Paragraph 8 of the affidavit, Lordship.
Yes.
That with regard to the statement made in
No, the last sentence.
the state government is responsible for ensuring that no ingenuine candidates can get selected against any post or services reserved for bona
So
fide.
this is your ground.
Yes,
that
yes, 100%.
You want only genuine people.
Yes, that is the only reason.
Now the question is, the authority which issued the certificate is a part of the state government and a certifying authority.
That is their loss. That is their loss. But
Where is the provision under the act that once a certifying authority has issued a certificate, you can go on verifying on the ground that it may be forged, it
no,
may
that
be
is the only
not genuine.
that is the only that OM is standing in the background, Lordship.
Why did you bring out that OM? Or whether the OM is to be utilized,
Because
implemented
yes,
in
the
all
reason is
sundry cases.
the reason is written is as the rights of person with disability act 2016 as well as rights of person with disability rules 2017 is silent about such situation and therefore in absence of a provision to tackle a situation as explained above,
First
the
you
state
show
has
us, that once a certifying authority is issued, it can still be verified. Assuming in the case of this petitioner, after assessment you find that this man disability is below 40%. Instead of issuing a certificate, you should have referred the matter to the certifying authority, saying that this man's certificate is not correct or not genuine or whatever grounds you want. Instead of you issuing a certificate, whether you are the certifying authority, have you been identified as a certifying authority?
actually Lordship, to streamline the problem, Lordship.
You have all good intentions, but these intentions must follow the rule of law.
And Lordship, this medical board is now no other than it is a GMC, Lordship.
So it's not GMC, it is a certifying authority issued by
Earlier, the
a
certificate from various district it has come, Lordship. That is true.
No, you have a notification, right? Notifying who are the certifying authority, not everybody.
Well, they have
Yes,
notified.
Mr. Upamanyu, you have a notification giving the list of certifying authority.
And Annexure 1.
Then why you have a medical board overriding the joint director's view? Unless you have specific reasons to say that this is not the case, this is false, this is not genuine.
Basically, Lordship, our intention is good, Lordship. We only,
Intentions are the only means to go and do something, that why you need rules of law and court and everything.
we only
Whether
wanted,
your
we
mere
only,
statement that your intentions are not
Lordship,
changed,
we only wanted the deserving candidates should get, Lordship.
that's not right. Then you make a rule, say that whoever you feel a deserving candidate will get application. Why do you go for the uh, the certifying authority disability certificate? This is the mandate of the central bank. Binding on
That I got for Lordship. We cannot say that authority given by one doctor cannot be there. The certificate given by one authority cannot be there because it's a part of the government. Later on. That I got, Lordship, but we are taking as Lordship as a
unless you are able to justify it, you have to interfere with the notice.
See, I want to just, Lordship, I want to point out another one thing, Lordship. As per the OAM, after the point number 12, that is the procedure of medical examination by the board, 14.1 of the same OAM, Lordship, every government establishment shall appoint a senior officer of the department as the grievance redressal officer. So if he has any problem with the
He has
certificate,
no problem, you have a problem.
no, he's challenging the by the decision of the board, Lordship.
He's challenging the decision of the board. First question is whether the board has the authority to, whether your department has the authority or is justified in bringing out the notification. Unless it's so, mayor saying that so act of the did not have a provision, therefore be a fee. First show the provision. One certificate is issued, certifying authority is issued. In a given circumstances, you are entitled to revisit it and make a decision. From that, of the judgment,
Yes, I have gone to a judgment, Lordship. Then in the judgment, it means stated that the only intention we had getting that board is
then don't go on intention. We are not here to judge your intention. We are here to see whether procedure prescribed under law is followed or not. Whether the procedure prescribed under law permits take the steps that you have taken.
it is the language of the Supreme Court itself, Lordship.
Where
The judgment is of the state of Uttar Pradesh versus Ravinder Kumar Sharma, 2016 for Supreme Court 791. Last three paragraphs.
Ravinder Hariwal
State of UP versus Ravinder Kumar Sharma,
Sharma,
2016 for STC 791. Para number 10.
do you have a copy of the judgment?
A copy of it. Lordship permit, I just later on Lordship can take.
Read out.
The division bench of the High Court has ignored and overlooked the material fact that verification has already been done by the medical board, and it has been found that certificates of 21% was fraudulently obtained. The High Court has issued a direction in the interim order for physical verification of the candidate by the authorities, and in case he does not suffer from the disability so certified, the candidate can be subject to fresh medical test. The High Court has overlooked that on mere physical verification, it may not be possible to know various kinds of disabilities, such as that of eyes, ear impairment, etc. That can only be done by the medical examination, and particularly when the High Court itself has observed that in case there is genuine suspicion and fraud has been committed, medical certification can be reapplied. Direction issued in this regard has not questioned by the respondent, and in fact, process of re-verification was already over when the High Court issued the aforesaid direction. In our considered opinion, in peculiar facts of this case, of such as fraud and genuine suspicion raised in the representation lodged by the Viklang Sangh, and when 21% of such certificates have been found to be fraudulently obtained, there was no scope for the division bench to interfere and issue order to perpetrate fraud. It is to be declined in such a scenario, and no equity can be claimed by the respondent. In the circumstances, we set aside the appeal judgment order as per the division bench of the High Court and dismiss the petition. However, before taking any action against the individuals, they shall be issued proposed in the matter and thereafter decision will be rendered in accordance with law. Let this exercise be completed within a period of 4 months. The appeal is allowed to the aforesaid extent.
That is the case where there was some indication about the genuineness of the
This proceed, our only purpose to consider the board place that proceed
again,
no
you're going
general.
back to purpose, etc. Tell us, tell us, you show us that there is a source of power. There is a source of power. Otherwise, we'll have to issue it. There is no finding. Where are the findings of the medical examination?
That was by state consider that was by state court.
Produce the report.
If your lordship may one judgment, my lord. My lord, there is a to deal with such type of case, my lord. The Lieutenant Colonel Nitish's judgment is my lord. This judgment on indirect discrimination. The concept of indirect discrimination and the systematic discrimination has been
No, discrimination will examine after it satisfied that there is no power of the to go for reassessment.
here, my lord. It says that in indirect discrimination, my lord, the intention is not matter, my lord. The effect.
Just after 1 week, enabling respondents to produce relevant medical records pertaining to the various writ petitioners on the basis of which reassessment of the percentage of disability was undertaken by the medical board constituted under the insurance law. The medical reports of the persons concerned of the medical of the assessment undertaken by the medical board. Be also kept ready for perusal of the court if the needs to arise. So further, the respondents will respond to the contention of the petitioner that once a certifying authority notified by the appropriate government issues a disability certificate identifying the certifying that the person that the incumbent is the person with disability with benchmark person that the incumbent is a person with benchmark disability. The source of power for the government to issue the impute certificate notification for reassessment or re-evaluation of such certificate without there being any finding as to without there being any finding that these certificates issued by certifying authority are not genuine or are not after are issued without undertaking a proper procedure for the medical examination prescribed by the competent authority. That has been listed again after 1 week. The date to be fixed by the registrar.
My lord, part my lord.
You are not able to argue, no point, wasting time. You are not able to argue your case. We are only giving them an opportunity because there is an earlier order.
Classification, sub-classification. There is a sub-classification. PW.
All these high sounding words will have to be met from the pleadings and the arguments that and the statutes. Merely throwing words is not going to help. You urge your case, we'll hear you.
Your Lordship, my lord, in this writ petition is challenging the selection and appointment of respondents, my lord. The deputy district registered, my lord, district deputy registered cooperative society Karimganj, my lord, advertised grade 4 post for the grade 4 process server peon, my lord. Petitioner being eligibly applied for the post.
Where is the advertisement?
Page 15, my lord.
1-5.
1-5, my lord. Annexure C.
Yes.
Petitioner, next page is the my lord, petitioner, annexure D, petitioner is the OBC candidate, my lord. And his roll number is, sorry, my lord, number is 60. He applied for the post, my lord. He appeared in the written examination, my lord. He cleared the written examination. Lordship will find at page 17. Peon below, my lord, second column, my lord, peon 214060. See, number 60 number is the petitioner's number, man. 60. Then another candidate, my lord, respondent number 4, who also appeared. His number is 38, my lord, general candidate. Lordship will find below that. 38. Yes, my lord.
Yes.
Then, my lord, while giving appointment, my lord, the Bhavavasi was held, and while giving appointment, he was given appointment in the reserve category. Next page, my lord, page 18. Lordship will file category peon OBC MOBC 38. He actually cleared his written examination as general category candidate, but he was given appointment in reserve category candidate. That is specifically my case, my lord. And they have filed their affidavit. They have not whispered anything how this general category candidate can be given appointment in reserve category candidate. Though they have said that on the next very day of the declaration of the result of the written test, my lord, they have issued a corrigendum, but do not specifically say anything. It do not say that, my lord.
Where is the origin?
That lordship will find in their affidavit in opposition at page 76, my lord. Page 76, second column, my lord, peon. OBC stroke MOBC instead of OBC with roll number 38. It do not say, my lord, general or something instead of general OBC, nothing like that. It says OBC MOBC.
Page number?
Page 76, my lord. Running page
list.
76.
Merit list. Merit list.
Corrigendum, my lord.
76.
Yes, my lord. Running page 76. Affidavit filed by respondent number 3.
Yes, origin.
Yes, madam. Annexer R1. Second column, my lord, peon. OBC stroke MOBC. Instead of OBC with rule number 38, so and so, so and so. And instead of, it is not clear, my lord, whether it is not written also that instead of general, it should be MOBC or OBC. And in their affidavit, they have not clarified that. There is no whisper.
What is the, kindly read this again, this part, category OBC, MOBC.
Category OBC stroke MOBC instead of OBC with roll number 38, 40, 60, 62.
60 is your.
My. I am OBC.
Then
62, 66, 207, 215, 275, so and so, so and so. Then, my lord, instead of 21, 40, 60, I also could not follow, my lord, what they want to say.
yes.
Basically, this is my case. They have not explained anything in the affidavit also, how the respondent number 4 could be
What has
adjusted.
happened to the private respondent now?
When I appear for the private respondents, they have been appeared, observed. They, I can explain the things, Miller. He may continue his arguments. I can explain.
His argument is only that.
Very well. Miller, so far as the projected case is concerned, it says that there has been a shifting or swapping of categories, which ought not to have been done. Pausing for a moment, if I'm with the same page with my friend on the other side, he means to say this, that whatever was indicated on 19 notice, 19/2/2014 notice, that is the first screening test outcome, Miller, that should be adhered to. That should be adhered to. The writ petitioner, willingly, unwillingly, knowingly, unknowingly, has chosen not to deal with the corrigendum in the writ petition. So the projection given in the writ petition is, although the notice says this is the category, but the result says quite another, without mentioning about the intervening corrigendum issued, correcting the position of things. So that would be a wrong projection made in the writ petition, for which it is liable to be dismissed outright. Now we bring the corrigendum to the notice of the authority, to the Honorable High Court in response to the pleadings. We say 19 was the notice which gave a roll number with the corresponding category reserved or unreserved. The mistake being there, being rectified on the next day, that is 20th, we did not have the occasion to agitate or have a cause of action to raise the grievance. Now, this 20th was the corrected thing, which they chose not to challenge till date. Not to challenge till date. Rather, they moved ahead saying that the 19 was wrongly reflected in the 26th, the final thing, the outcome. So what happens is, we take it step by step. Initially, when I apply for a post, I have to invariably apply indicating my category if I so belong to any other reserve category, which I so did. I make a statement, I did, which everyone else did. Now, when the call letter is issued, again, nowhere is there a room for indicating the category, reserved or unreserved. It's a plain thing inviting that you come there on such and such date, such so and so, with the modalities you have to adhere to.
So his case is, he has presented it only on one ground, that his name was, he is a OBC category, MOBC category certificate. He applied.
He applied.
He's appeared in the written test, he was shown to be successful in the OBC category. But when he appeared for the, thereafter he appeared for the Viva vote, and then the results were declared, and the private respondent was found to be appointed in the
Correct.
OBC category.
Correct.
Now, his ground is that this swapping
was not permissible.
Was not permissible, or for
without making a whisper that on 19th of February.
Let us understand what is the effect of this swapping.
Nothing. Things fall back in place.
How?
But I need to put a container in a particular place. I put it wrong.
You belong to general or OBC?
I'm MOBC.
You are MOBC.
I'm MOBC. I applied under the correct category. The call letter did not reflect so. On 19th of February, when it reflected wrongly, they corrected on 20th of February. What I all want to submit in all fairness, this ought to have been a part of the pleadings.
So both of you belong to the same category.
Same category. So I qualified. My qualification, that I sailed through, is not on the challenge. Even the corrigendum is not on the challenge. Rather, they chose to suppress it. Now they are not being able to read the corrigendum correctly. May I try to explain that part? Yeah. Page 30 of my affidavit. But without challenging the corrigendum, nothing remains in the writ petition.
All right, corrigendum.
Page 30.
Yes.
Is the
Bordoli appears for the department.
I know.
I'm addressing the court.
We are aware of that.
Page 17 of the writ petition and page 30 of my any affidavit would be read conjointly.
You read.
Page 30. In continuation to the office advertisement dated 21/1/2014 and notice dated 19/2/2014, corrigendum is hereby issued to read the category and roll numbers of successful candidates of screening test held on 16/2/14 for the post of PSP and peon, which were entered /dropped inadvertently in the earlier notice dated 19/2/14. I come to the peon part. That's the second group, peon. May I read it? Category, quote, OBC/MOBC, unquote. Instead of OBC, so it has to be read as OBC, MOBC instead of OBC. That's the first thing they mean. With roll numbers 038. I come in, 038. So and so, instead of the following group. This is first. 038 comes in here. OBC, MOBC with roll numbers this. It comes in here. Following the women part, I leave. The category unreserved, that's the last part, what is there? Because it is general. Category unreserved instead of general. So they want to put it unreserved. With roll number so and so, instead of 038, what is there, I go up. So this general where I was put, I am now put correctly in the category OBC, MOBC. That's the origin. That's how it reads.
So the second part, category unreserved.
Lordship.
The corrigendum is to the effect that
So far as I am
instead of
concerned,
general, it should have been unreserved.
it should be unreserved. That's
This is
okay.
one. And the other is that
038 goes out,
these numbers are
would
there
stay, and instead of these numbers.
instead of the,
So 038 goes out. So where does it go? It goes to MOBC, OBC, MOBC. And if I may invite my lord's attention to the first line of the corrigendum, which says, which were entered / dropped inadvertently in the earlier notice 19 to 14. That's at page 17 of the writ petition. So there was some errors which had crept in on 19. Before I could say, sir, I belong to MOBC, please correct me. They issued the corrigendum on 20th, on the next day. So I did not have a cause of action. They had. They did not approach the court, rather they sat over it and absolutely silent tactful ploy, suppressing the basic fact without challenging that, And thereafter we continued, and if I invite my lord's attention to page 26 of my affidavit, that's a running contribution page of respondent number 4.
Yeah.
Respondent number 4 or 25. 25. Paragraph 8. What happened thereafter? May I read? That by order dated 28 to 14, issued by the district deputy registrar of cooperative societies, Karimut, the deponent was appointed as a peon and posted in the office of the assistant registrar of cooperative societies, Ramkrishna Nagar audit branch, under district deputy registrar of cooperative societies, Karimut, and the deponent is continuing to discharge his services. That it is relevant to state that by order being number so dated 12/5/22, the service of the deponent has been confirmed as a grade 4 peon, and the confirmation is with effect from 3/3/14. Now,
what is the state of the state?
similar. They support it. The corrigendum, they take the stand and they support the stand. That's all.
Yes. Let us hear it quickly.
Mr. Kaushik, I have stated in my affidavit that on the results which were declared on 19 to 2014, there are some clerical errors here also, and subsequently on 22 2014, the fresh results were declared, Your Lordship. And to that effect, Your Lordship.
Where is the, you say, Mr. Panik, you say you belong to MOBC. And you indicated that in your application. Where is that application? Where is the application?
Lordship, I have the copy of the application of the private respondent, roll number 38, and along with the minutes of the meeting of the board members of the district selection committee, which was held on 22 2014.
Is it available here in the meeting?
No, yes, Lordship, it's not available. Actually, on the last occasion, I have been asked to produce the record. I have the original record.
Right, show us the minutes and the application.
Okay.
Certificate going.
That must be relevant portion. That is the minutes of the meeting dated 22 2014. On the next page, Your Lordship, resolution number 2, Your Lordship. Lordship, got it?
No, let us first examine the application.
Lordship.
The caste certificate.
Caste certificate, Lordship. The Lordship, I have the originals of the application.
Let him go.
Let them file a short affidavit, madam, including.
No.
Including-
2015 matter what? Sort of-
No, yes, ma'am, next week Lordship will take, let them bring on record, my lord,
Why?
so
Go
that
it
we
on-
get a chance to go through it, my lord.
You go through it now. We are giving you a chance, simple chance. Go through it. Go through it.
Story sense. Via which they did appear. Yeah. So the guidance, but he is challenging that as a tangential to say that these things were not there in the law. Mine was,
But
was
he is not for applying for that post.
he did not apply for that. And we say, and they also say that it was inappropriate not for the public. He is not challenging directly. He has no locus to challenge that. He is bringing in as an extra to canvas his point.
No, but he has to, he is not a candidate for those.
No, he's not a candidate. But the corrigendum is not in the chat. Likely, you know, cannot read it.
Can you
Ma'am,
bring it on
ma'am,
record, Mr. Counsel? Can you bring it on record?
Yes, sir.
Bring it on record.
Lodge.
Let him have a benefit of
Lodge.
completing his instruction. Heard Mr. S.K. Chandra. Mr. Bonik appearing for respondent number
456. Every district. Later, district 7 takes time to file the affidavit and then come time to file the response. Thereafter, so they can time
Why don't you draft and give it to us? We'll sign it.
pay for that. Every
We are intending to pass that order. Allow the court to pass that order. Or better you get an order, give it to us, we'll sign it. Mr. G. Bordola appearing for the Cooperation Department. The challenge in the writ petition is to be a selection and appointment of respondent 4, 5, and 6. In the pursuant to the advertisement dated
21/1/2014.
21/1/2014. Or where is the advertisement here?
Page 15.
15 of the writ petition. my lord.
It- Dated 21 January 2014. Issued by the district registrar of Cooperative Society Corimbatore for calling for suitable candidates for appointment at the post of process server peon and peon. Calling for suitable candidates for selection and appointment in 5 posts of process server peon within bracket PSP and 9 posts of petitioner and the respondent number 4 applied for selection and appointment at the post of peon. Respondents 5 and 6 had applied for and were selected for appointment at the post of process server peon. The petitioner claims to be a member of caste recognized in the state as OBC. You are OBC or
OBC, OBC.
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 It is his submission that pursuant to it is the contention of the petitioner that successful pursuant to the petitioner being successful in the written test, his roll number was, along with other successful candidates, was notified by notice dated 19 February of 2014. Stop. The petitioner's roll number was correctly notified in the category of OBC. Respondent number 4, four's roll number, however, was notified under the category general. The Viva OC was fixed on 20. As far as the minute,
22 to 2014, Your Lord.
22,
Yes, sir.
22 to 2014. On the subsequent day, which is 20,
22, 2014.
no, where is the corrigendum or
Corrigendum of 20, 20.
20? On the subsequent day, that is 20, the corrigendum was issued, whereby the, where is the corrigendum?
Lordship, page 76 of my affidavit in opposition, Your Lord.
Whereby the sorry, the petitioner subsequently came to the inform that the respondent number 4 was appointed from PO under the OBC category, although its name was initially reflected in the category of general. He therefore approached his court of error. Pursuant to issuance of notice, the respondent filed their affidavit. The affidavit filed for the court by the department. Corrigendum dated 20/0/2024 is enclosed. Stop. As per this corrigendum, the roll number of the petition, namely within code 038, was shown to be in category OBC/MOBC instead of general. The respondents representing the cooperation department as well as counsel appearing for respondent 4 and 5 sub that this corrigendum, the issuance of the corrigendum was not placed before the court by the commission, trying to protect the case that the petitioner's appointment was made in the wrong category, or it was made in the category of MOBC, OBC, MOBC, when the respondent number 4's appointment was made in OBC, MOBC, when he had earlier been shown to be successful in the written test under the general category. Stop. The petitioner being this aspect of the matter was not brought to this court, the writ petition, and consequently, the same not being under challenge, there is no merit in the petition. The same being. As per the earlier order passed by the court, Mr. Bordo placed before the court the relevant records, which revealed that there was a decision taken by whom?
By the Board of District Selection Committee. Your Lord.
By the district selection committee for the process of selection of in pursuant to the advertisement dated by and wherein there was a resolution adopted that there had been clerical error in the notice dated 19th of February, January.
Lordship,
19th of February
19th of February 2014, Your Lord.
2014, which was quite be corrected, and certain roll numbers were wrongly placed in the category, were placed in wrong category, and certain roll numbers of candidates were successful were not even pursuant to the origin dated 20th of February 2014. Was filed. The Standing Council Cooperation Department has also placed before the court copy of the application filed by the private court, which reveals that the at the time of filing the application, the respondent 4 had indicated that he belongs to the OBC category, and a certificate to that effect also placed before the court, as is available for the record. Since this document will have a bearing on the decision of this matter, this court considers it appropriate to permit the respondents to bring it on record by way of filing an affidavit, and the petitioner may consider filing affidavit to advise the list again on 1st of May.
My lord, will keep it parted, my lord.
The partner.
My lord, actually on 21/7, Lordship directed to produce the record on
All right.
record means, my lord, where we have said, my lord, that during the Vivavosi, he has not put his signature in the OBC sheet, rather in the general sheet.
All right, you bring all this, whatever you want to argue.
No, I am not, man. He may be on last occasion he was directed to produce.
The standing council will also keep the relevant record.
In order dated 21/7, my lord. 23.
Relevant record in terms of order dated
21/7. 21/7, 23.
23.
Yes.
Available in court for renewal if required. I will the learned counsel, Mr. Modi, further submits that the petitioner cannot have claim in respect to the appointment made by respondent 5 and 6, as he never applied for the post. So
In that order, Lordship has already indicated 21. Okay. Okay.
Lordship, in the office notes, Lordship, regarding the corrigendum, Lordship, there is no.
Yes.
In the office notes, Lordship, regarding the corrigendum, Lordship, regarding the correction, Lordship, that is not reflected in the office notes, Lordship. From the record, it is.
Gavura.
Yes, Lordship.
Yes. You were selected as one.
He was not selected.
I was selected as a Gav Pradhan. Lordship, Lordship has seen in the previous case, Lordship, there was a proper minus. In this case, Lordship, it is opposite, Lordship, there without any minus, without any office note, Lordship. They have simply issued a corrigendum replacing my name.
Lordship. Similar names.
In similar names, but my father's names are different. Address are different.
One is Nurul Islam
Yeah.
Ahmed, and the other is Nurul Islam Sheikh.
Nurul Islam Sheikh.
Yes.
And my father's name is different. His son has name is
Lordship, the Lordship, the selection was the Nurul Islam Sheikh was selected, Lordship, but it was wrongly reflected in the selection in the notice, Lordship, notice for appointment, Lordship. After that, immediately after 30 minutes, Lordship, it was changed, Lordship.
Who noticed?
Lordship.
Who noticed the error? Somebody must have noticed the error. It was
Is that-
published.
Yes, Lordship.
It was published.
Yes.
It is not a case that before publication you notice the error and therefore correct. It was published.
Yes, it was published.
Then somebody noticed the error. and then corrected it and published it again. Who noticed?
That is not stated in the office notes, Lordship. This is not stated in the office. I am not find out.
But somebody must have stated that he has wrong.
But from the records, Lordship, it appears that the respondent got the higher marks. It is in the comparative statement or the individual.
Where is the select list?
Yes, this
In the record? Is it available here? Somewhere? No.
in my record, Lordship, the comparative statements are there.
Why three petition? Why three petition?
Three?
You have filed three petition.
Lordship, all different facts, Lordship. All different facts.
Yeah, I marked as A, B, and C, Lordship. A is the comparative statement, B is the individual marks of the petitioner, and C is the response.
And these three petitions have been tagged because of the Lordship, common Lordship, CM Switzerland case, Lordship, wherein such thing has been filed. That is why Lordship, these three petitions have been tagged.
B and C is the individual mark.
Why there are two different sheets? One regarding individual mark. Why? B and C.
If B and C, Lordship, B for I think it is the petitioner sheets,
No.
and C for respondent.
No. It is pursuant to one advertisement only.
Yes, Lordship.
They are all applied for the
Yes,
same advertisement.
yes,
Same selection.
same selection.
So why different sheets?
But there is not different sheet, Lordship. Same sheet is continuous, Lordship.
Continue.
Yes.
How many candidates were there?
Total 70 lots, Lordship.
Huh? 70.
No, lots, total 70 lots.
70 law.
Yes, 70.
You got lesser mark.
Lesser mark lordship, kindly say how many members there are individual seats.
Huh?
Because on the earlier occasion, there are 4 members in the selection committee.
There are
Only
3 members.
No, it is 4. That
Okay,
itself
okay.
is a illegality.
From where do you find it?
Yes, lordship.
Page 13, Lordship. 13. Paragraph 2.
One. Page number.
13 in the writ petition, Lordship. Paragraph 2. Selection boards. Merit.
Yes.
The Deputy Commissioner of the Principal Secretaries of Autonomous Councils areas shall make the appointment of the Gaumburas on the recommendation of the selection boards constituted for this purpose by the Deputy Commissioner of the Principal Secretaries of the Autonomous Councils area, which shall be composed of the following members: Deputy Commissioner of the Principal Secretaries, ADC Revenue Lordship, or the SDO, Joint Secretary Revenue, a circle officer of the revenue circle. Within that, Gaumbura is located. That is 3.
Yes.
3 members.
3 members.
Lordship, it is 4. The selection committee was considered with Atika Sultana, Deputy Commissioner, then Saibur Rahman, who was the ADC of South Salmara Mankasar, then 2 other members of the selection committee were Vikramaditya Bora, ACS Circle Officer,
Yes, Lordship.
and Deputy Secretary BTR, AK Elias Ahmed.
Lordship,
4 members.
That is BTR areas, Lordship, regarding BTR areas.
ACS Circle Officer, Deputy Secretary,
Yes.
Transport Department.
No,
Yes.
from
They were the 4 members of the
BTR.
selection.
where are you reading it?
Lordship, page 77 of my running page. Lordship. Page 77. And also page 138 also. Page 138. Page 138 of my affidavit in reply. Lordship.
Yes. Yes.
It starts with paragraph 1, page 137, paragraph 7. That with regard to the statement made in paragraph 8 of the affidavit version, the answering deponent begs to state that during the pendency of the writ petition, there were several complaints with regard to illegal gratification of collecting rupees 5 to 12 lakhs from each of the 70 candidates. by the chairman of the selection committee, Atika Sultana, who at that point of time was serving as the deputy commissioner, South Salmara Mankasar district from 2017 to 2020. Saibur Rahman, ADC, who was the member secretary, while the other two members were Bikram Aditya Bora, who was serving as the circle officer of Mankasar,
Yes.
and A.K. Elias N. Ahmed was the circle officer of South Salmara when the
Yes.
reassessment appointments camp took place.
Two
The
circle-
two members of the selection committee, Vikramaditya Bora and A.K. Elias Ahmed, were placed under suspension on 15/12/2021, and both of them were arrested and in judicial custody. And
What is this order? Who has passed it? Or what? No. Who's read it?
my repeat.
Earlier read it.
No.
You are reading from page 90, 97, 98.
I have read from page 138
Statement of the statement of the
of my
petitioner.
opinion. Reply.
It is a statement, Lord.
138. Sorry. There are 2 page numbers here.
Yeah.
Oh.
Yes. No, this statement you are making, you're on what basis are you saying that there are 3 when the this particular provision shows that it's,
No, Lordship.
sorry, 4 when the provision shows it is 3
Lordship, he is right, Lordship. So far, he is right.
PTC
Lordship,
area.
yeah, no, Lordship, there are 2 circle, Lordship. Here in column 3 of the paragraphs 2 in page 13.
Page 13.
13.
13 of
13 of the writ petition, Lordship.
And that is why in the cost title also,
Just a second.
Hmm.
13, paragraphs 2, Roman 3.
Yes.
Third member, Lordship. The 1, 2 is the clear, 1, 2 is clear, 1 deputy commissioner, second one is the ADC revenue, Lordship, of that district. Now, third, circle officer of the revenue circle within which the Gaubura area is located. It means, Lordship, in that Mankasar district, there are 2 circle, Lordship. Both the circle officers are the member. But in case of the respondent, Lordship, in case of the petitioner's Lordship, petitioner's lot, Lordship, in lot number 12, Lordship, the 1 circle officer, he is from Mankachar, Lordship. He was
the lot of the petitioner is in which circle?
yes, Mankachar.
And the private respondent?
Same.
Same.
But there are 2 circle, Lordship. There were 2
There
circles.
may be circle,
Yes,
more
Lord.
circle, but the concerned
He
circle-
stated in his statement.
concerned circle
Yes,
officer has to
Lordship.
be a member.
Yes, Lordship. But in the entire process,
Effectively, there are 3 members.
effectively there are 3 members, but in the entire selection process, there 4 members were there, Lordship, in the entire selection process.
So there was a common selection for
Yes,
L for both
yes,
the
Lordship.
circles.
Yes, Lordship.
from the search sheet also, Lordship, it has been reflected, Lordship, may I clarify?
Okay.
From the search sheet file in the same Villain case, also it is during investigation, it is found that oral interview for the post of Gaubura under Mankasar Revenue Circle was held from 22/10/18 to 26/10/18. A merit list of candidates was prepared by the selection board. The state merit list was signed by Mrs. Atika Sultana, SCS, D then Deputy Commissioner, Saibur Rahman, SCS, D then Additional Deputy Commissioner, and Bikram Aditya Bora, SCS, D then Circle Officer, Mankasar Revenue Circle. That is why, Lordship, in the writ petition also I have made for all.
Notification, the notification is very clear that
Yes,
it is, shall be comprised of 3 persons.
Yes.
Right?
But Lordship, all the search sheet and other things, Lordship, all the 4 members have been Lordship, search sheet have been filed.
How is it relevant for the purposes here? Your issue is that you ought to have been selected, he was reflected.
Yes.
The records here show that he's got more mark,
Yeah.
1 mark or half a mark or 2 mark.
That is because of the manipulation and the illegal test,
So that
because I was,
that manipulation by itself is not discernible unless you point out from some records or.
Lordship, the very fact, Lordship, all the 4 members of the selection committee have been arrested for this particular,
Mr. Kautal,
selection.
You know how the criminal law operates.
Lost.
Unless they're convicted.
Yes.
Unless they're convicted, they're innocent, deemed to be innocent.
And Lordship, from when the earlier records were produced, Lordship, this honorable court has directed them to show me the record, Lordship, and I have noted down the record, Lordship. From the record, Lordship, on 14/6/2018, the last corrigendum was issued before issuance of the final order, final select list, Lordship. On 14/6/2018, Lordship, I have noted down from the Lordship record, corrigendum list is prepared by the Secretary Officer of Gaon Pradhan at page 214, Dipankar Nath, ACS. I have noted down, Lordship. And 14/6/2000 corrigendum list 2146 draft of corrigendum is prepared. And Lordship, on 36/2018, a minus held on 36/2018, 24 numbers is prepared at page 259 for approval. So in 14/6/2018 was the last corrigendum, Lordship, they have issued. They finalized the select list. Now how come, Lordship, when the final select list was published on 2019, my name was replaced. So last corrigendum was on 14/6/2018. That is why, Lordship, this court has repeatedly asked them to show the note sheet and the other things. Lordship. This is clear manipulation. And Lordship, even if your Lordship does not go, doesn't want to go into the that's it. There are, Lordship, I have brought on record, Lordship, there are manipulation. There are, Lordship, they are overwriting the numbers of lot number. All are reflected in the search sheet. So now, Lordship, that record which has been produced before, Lordship, that is a neatly type 1, Lordship.
No. Okay.
Because so many illegal
You are saying that the corrigendum was put up on 14/6/2018.
Yes, last corrigendum, 14/6/2018. That was the last corrigendum. At page 214. I have also noted down the page.
Yeah.
Page 214, Lordship.
Then what happened?
Then, Lordship, when the final select list was published on 9/7/2019, this corrigendum was issued. After issuance of the select list. In the past select list.
Where is that corrigendum?
Here.
Sorry, where is the select list?
Select list, Lordship, 47.
47. This was published when?
On 9/7/2019. Clearly reflect at page 12, my name, my father's name. Then my father's name cannot be a different for clerical mistake. Himpara, lot number 12, at serial number 12.
Then where is the corrigendum?
Corrigendum, Lordship, at page 53.
On the same date.
On the same date. And his father's name is Gogan Bepari, Lordship. They also reflect. And the address is Bhimpara. If only my name would have been, Lordship, because of the similarity, but when, Lordship, both the fathers' names are also different. Lordship may kindly see one more page, Lordship, page 143 of the running case, Lordship. In terms of the Lordship criminal case also, they have acted. Initially, they acted. Lordship. Lordship may kindly see page 143 for one shot. Page 143 of the running case.
Yes.
And 4 of them are also arrested in terms of the CM's vigilance case. Lordship. Yes. So they have acted. Lordship, I just try to, although Lordship, with CM's,
Is it before or after conviction?
after the selection, Lordship. After the
Before or
selection.
after conviction?
Before conviction. But initially they acted on the report. Lordship. Names were also there, page 143.
You go to the office note.
Lordship.
There is a proposal to send a corrigator. The corrigator was paid.
Lordship.
Naturally, it goes before different officers. Meanwhile, somebody filed a writ petition. This writ petition was filed where there was some interim director not pick up certain posts.
Yeah.
Which
That is separate
one of the
issues.
perhaps include this particular dot or this particular. There may have been some, but fact remains that the corrigator was there to test before the authority.
Lordship, my humble.
It is what you are trying to project.
Uh,
The results were declared.
okay.
Then there was some manipulation by and therefore the corrigator was.
Yes.
According to you, results were declared on 2019.
19.
Corrigator, the process for corrigator started on 14/6/2000.
No, yes. That was the last corridor. In that corridor, Lordship, my name was there. I've seen the record, Lordship, on earlier corridor. When this was placed before the novel court. That is why I have noted down, Lordship.
Page
Page
214.
Yes, Lordship. Page 214. Signed by Dipankar Nath.
Where is the page 214 of the record? 214. That's two.
Yes, it is 13 look.
There is some corrigator place that 214. This is the note sheet.
Yes, yes, Lordship.
So in the file at serial 214, there is some corrigator place. Where is that corrigator?
I will.
This is not a record, but which I have heard of. It was a big record.
This is lordship, this record was received from the, is the,
We have marked that portion for your,
yes, lordship, I got it, lordship, but
this, repeat the page number 1.
yes,
This is
lordship,
the page
I
214
got
where
it.
the origin.
But that 214, lordship, in my hand,
That you get it, get it,
lordship, lordship,
show it to us.
lordship, I will, I will.
Get.
That is the before selection also. It was not after selection.
Even before selection, there is a corrigendum.
Yes.
Why would you issue a corrigendum before selection?
14/6/2018, lordship.
What corrigendum?
Yeah, lordship, that is not in my record. That is not in my hand. But
yeah.
That was May 2018. That person that made the earlier come. They are
Produce letter. This is the continuation where you read that note.
yes, lordship,
you read it and tell us that it appears
lordship,
pertaining
on
to some other selection, some other.
yes, lordship. I would say, lordship, is a lordship put up in favor of that the corrigendum list is prepared by the scrutiny. So it is 18.
Reports. Lots felt necessary. Council for the Commissioner, Council for the State, directed to produce complete reports. The process undertaken for appointment of Lambuda under the Pankachar review. Pursuant the advertisement. Where is the advertisement?
Advertisement lordship at page
19 March.
lordship.
19 March.
Advertisement lordship at page 19/5/2018.
19/3.
19/5/2018.
19/5. Relevant reports of export. How much time do you require?
Okay, 2 weeks time.
2 weeks time. Place the same report. It's the an English case board. Respondent one, Mr. Islam board. 7. And MS Borwa, your appeal.
Lordship, that's a comparative list is 47.
No, we give it back to you. Take it. Take it. The comparative paper and the photocopy of the origin. The court.
I beg to mention in series matter, lordship, a supplementary list,
Okay, what we-
47 to.
Different series.
Dif-
Is that different series?
Yes, your lordship. That medical review medical board says. Lordship, what we have taken, lordship, we have to file our affidavit in this matter. Otherwise, lordship, our stand will not be there. On what ground we have rejected him? On what clinical? That's why, lordship, we require we have
In all the matters.
lordship
You
in
want to
all
file
the
in all the
matters
matters.
because all the matters are different on different.
No, then we'll have to give them some protection.
Lordship, yes,
definitely.
protection is there. Subject to outcome of the petition is there, lordship.
What outcome? See, your ground is you have rejected him on a medical ground.
Yes, sir.
You have your own
Guidelines. Yes,
In terms of these guidelines,
lordship.
you disagree with the views given by doctors or specialists in the civil
Because
hospital in
lordship-
some matters.
Lordship.
So there has to be an explanation why it is disagreement. What was the occasion to disagree?
The lordship, that's why on what ground we have rejected, on what clinical ground we have rejected that.
You produce the records, we'll examine it.
That records are there, lordship.
You produce it, we'll examine it.
That records.
You file an affidavit, we have no difficulty. You file an affidavit. These are all matters of 1920, something like that.
No, on 24.
24.
All 24.
All
25.
Already selection process has been over, my lord.
Then
And subject to outcome of this writ petition are their lordship order.
we have already disposed of 2-3 matters.
Lordship,
Yes, my
on
lord.
that 2-3 matters, we think lordship, the order was not yet uploaded. We have to review, come up for a review, lordship, because the lordship has passed an order in terms of OM, that omitted OM, lordship. That review medical board was there, lordship. That 21 notification, lordship, that provision where he can go for the review with all the documents has been omitted in 21 notification.
21 means?
That new
New.
Yes.
Huh.
So, lordship, that's why we think, lordship, an affidavit will require, lordship.
Yes. But
My lord, we just don't understand why the affidavit is required, because it is already on record.
affidavit is required. It is nothing difficulty in understanding. But the question is, you have not filed your affidavit.
Exactly, my lord.
This is a process of selection.
Lordship, earlier,
You have not been able to file an affidavit in how many matters have you? How many matters do you want to file your affidavit?
not all in any matter, lordship.
Then?
In this matter.
And my lord had already disposed of 2 matters, 3 matters.
All right, we'll see whether they will file a review or an appeal or whatever. We'll see on that. But whatever it may be, either you say that yes, we want to file affidavit, this is the time frame, we'll file it.
Lordship, within 3 weeks,
Right,
lordship, we will file, lordship.
But you see, this becomes a repeated exercise.
Yes,
And the issue is very small. The issue is in a very small compass.
Understand, lordship, but the stand taken by us on what ground we have rejected, that clinically, that has to be, lordship.
So that is a part of the record.
Yes.
All you do is produce the records and argue on this. You can't improve on your records.
Yes,
Whatever
sir.
is there is there.
Yes,
Whatever
sir.
is not there is not there.
Lordship. That
is already on record, my lord.
That
whatever is there, what grounds, what medical records are there, why is it been rejected, you explain and you decide the matter.
Then
what?
Then we will.
Then lordship may hear it the matter, I think.
Hear the matter.
We will ensure at least by today the copy is uploaded so that they have the benefit to know on what grounds we have rejected it.
Yes.
At least one petition we have closed it because there was no, he did not qualify in the written.
Yes.
And the rest,
That,
I think.
that was I think, lordship, that item number 3 will, which was not yet uploaded, lordship.
Some other grounds are there, that some defects which is not enlisted in the general grounds for rejection. If it is in the revised guideline and it is in the medical record itself, my lord. Lordship may hear it one by one.
Yes, we can hear it. Subject to they being ready to argue the matter.
Let it be on then, lordship, Tuesday, lordship, let the order be uploaded.
দাদা আজি কৰি দিয়ক বাৰু হয় দা যিকেইটা আমি কৰি দিয়ক
Order to he did a order to it to some
আজি যিকেইটা আমি কৰি দিয়ক
You had agreed that we had prepared a chart. You had agreed for the classification of the matters. I think this is the one.
Yes.
It was done in your presence.
That chart was not given to us, Lord.
Huh?
That chart was not with us, Lord.
Chart was not given.
Not given, Lord.
I think it was prepared by Mr. Mozumdar.
Yes. It was not
You
given.
have not. You have submitted to the court. You have to submit it, a copy to the other side.
We have not received.
You give copies.
Oh dear.
You examine this and then
Lordship,
you'll come back
Lordship,
after 1 week or after the holidays.
Lordship, after
My
the
lord, maybe before holidays, my lord, if possible.
No, before holiday, I
Already,
don't
my
know.
lords have disposed of 3 matters.
We'll continue to
Then
do
on,
so.
therefore, maybe before holiday, my lord, any
Before
day.
holiday, not possible. It has to be after.
immediately after holidays. 22.
29th. 29th.
Lordship. In between, if required, Lordship, we will file our
You
affidavit.
file your
Lordship.
29th.
My Lordship.
These matters, as per the earlier order, the petitioners were required to prepare a chart classifying the matters and place it before the court council. The same was done on the last day. However, copies thereof were not served on the council to the respondents. So today, when the matters are called up, council to the respondents submit that this list classifying the matters not available, and therefore it is not available. And they seek liberty to file affidavits in individual matters. So, one of the counsel appearing for the petitioner, Mr. D. Deca, has submitted copies of the charts to the counsel for the respondents in court today. So, under such circumstances, the court is of the view that the respondents should be permitted some time to complete their instructions if so required, and point out if there are any suggestions in respect of the charts which has been shared with the respondent councils today. So, under such circumstances, matter be listed again on 29th
Lordship.
of April. Liberty is also granted to the respondents to file their affidavit and to the petitioners to file their reply affidavits if so required. List again on 29th.
My lord. Much obliged. My lord, interim order may be continued.
Interim orders were passed, where issued, will continue.
Much obliged.
May I please your lordship? Lordship, similar prayer lordship regarding item number 36 to 40 lord.
36 to 40.
Yes, hearing matter lordship.
This is also connected.
Yes, lordship, NRC matter. All are service matter. NRC related matter lordship.
No, these are not NRC matters.
36 to 40 lordship.
What do you want?
Lordship, I am praying for adjournment lordship.
That is, you have to make it at 10:30.
Sorry lordship, but
you wait until the matter is called up. I don't know what. Yes, 36 to 40. 36 matter nahi. You wait for the matter to be called up. Because mentioning is at 10:30. Now we can't allow mentioning now.
Item 27.
May it please the lordship.
Yes.
The two petitioners before this honorable court, they're junior engineers in the water department.
May it please your lordship, my senior Mr. Arandas is not present today.
You argue, you do it.
Kindly
Yes.
adjourn the matter for
No adjournments like this. If you wanted an adjournment, you should have made it in the morning, 10:30.
He left the court. Due to some urgency, he left the court.
Not like this. Yes.
Yes. The lordship will kindly come to page 43. Page 43, your lordship. There are two petitioners. Petitioner number 1 had obtained the AMICE from the Institute of Civil Engineering. It's a certificate, your lordship, which is equivalent to a diploma in engineering in the year 2012. Your lordship has seen that. Page 43.
page 44 is the petitioner number 2. He obtained his degree in the year 2016. Thereafter, your lordship would kindly come to page 48. Page 48, these are the minutes of the meeting dated 27/2/2017 held by the selection board for recommendation of names for the subsequent post of assistant engineer. Page 48, your lordship has seen that.
What is their stand?
The stand is, there are two stands that they had taken. The first stand that they had taken was that the degree that we had obtained
Is not recognized.
Yes.
But it is recognized.
That is recognized. That part has been over now. Now, the government has filed an additional affidavit, your lordship, which is dated 29/7/2024. It will probably be the last documentation in your lordship's file.
E 28/7.
29/7. 28/7, but yes, 29. Yes. Your lordship.
This is an affidavit in reply.
No, this is the additional affidavit in opposition filed by the respondent number 2. It's a 3-page document, your lordship.
What is the name?
Deepak Bhattacharya. It's the last documentation, your lordship. It's on July 2024.
Yes.
Yes. Now, the last stand which has been taken, your lordship will kindly come to the second page, paragraph number 3.
Yes.
That no NOC was obtained.
From?
From the appointing authority. That is what they've stated. Now, as far as I'm aware,
NOC at the time when you proceeded
with the court.
With the court.
Yes. Now, as far as I'm aware, your lordship, that pertains to Rule 13 of the Assam Civil Services Conduct Rules, where appointing authorities' permission is sought to be required. Now, to answer this query, your lordship may kindly come to page 42 of the writ petition. Of the writ petition, page 42.
Yes.
This is with respect to petitioner number 2. With reference to the above, I am directed to say that the department has no objection to your prosecution of degree course of Associate Member of Institution of Civil Engineers India, AMICE, under the Institution of Civil Engineers, Ludhiana, Punjab, on distance mode, subject to no impede in day-to-day departmental and official obligations vested upon you. That is in regard to petition number 2. The NOC had been granted. And in respect of petition number 1, I'll beg your lordship's attention to page 49. Page 49. The first big paragraph, your lordship, the details of their acquiring degree are as below. Your lordship has seen that. Page 49. Yes, the first paragraph, your lordship, 1, 2, 3, 4, 5, 6, 7. The 7th line from below.
Yes.
Shri Hori Deka has got NOC from Water Resources Department for the study course and acquired academic qualification through self-study mode. Shri so-and-so, Srimati Rohini Fangsopi had got admission into the degree courses before joining in this department as junior engineer. The bachelor degree obtained by... So we have already answered, it's already answered the query. And my name was recommended, your lordship, for a moment. There's a notification issued in the name of the governor at page 51. Page 51. Page 51, your lordship will kindly see. Annexure 6. In 2017, my name is at serial number 6 and serial number 7. It was recommended for promotion. All the other candidates in that notification have been promoted. And our names, your lordship, for some reason or the other, has been stalled for promotion. This is what the writ petition is all about. And assuming there was no NOC, it does not invalidate the degree. It may amount to a misconduct, if at all it does. But now the documents reveal that the NOC and the entry into the course in respect of the petition number 1 and 2, that is my submission. That is the gist of the matter, your lord. There's nothing else.
Yes.
Lordship, in fact, this is the second round of litigation, your lordship. Already the honorable court has discussed all the matters, all the aspects of this matter, your lordship. And we have filed our affidavit stating that the degree obtained by them are of distance mode, which is not recognized, Your Lordship. And
But
if
AICT recognizes his degree.
Lordship,
Where is that?
Ludhiana. We had
no, Your Lordship.
Where is the AICT is a party here?
AICT is a
It's a party,
Have
Your
they
Lordship.
filed anything?
Recognized, Your Lordship.
Have they filed anything?
No, they have not. But
no,
it is a given fact. This course was taken on regular mode, on distance education because
You take us to the AICT affidavit. Where is it?
AICT Lordship, we file affidavit.
Yes.
Where is your affidavit? Which date?
I think
It is dated 28/7. 28/7.
June, Lord, July, Lord.
No,
June, Lordship.
28th July.
26 June, Lord.
No such appointment is there, Your Lord.
No, if your lordship permits me to make a small submission, the aspect of study center or distant mode was dealt with by the Honorable Supreme Court in the matter of Orissa litigation that pertains to universities. This instant case, your lordship, it pertains to a technical institution.
Is there any averment to show that the AICT has stated that they do not recognize it?
No.
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 What
It is
have you
substantiated.
filed in your affidavit?
Lordship, we have
AICT.
That accordingly, the council, the AICTE council, in its 50,
Page number.
it is page 82. Page 82. The lordship will start from page 81, the last paragraph, subpara 8A, 4A. That the Ministry of Human Reassurance, its resource.
In this writ petition, have they filed? This is the affidavit.
This is the affidavit.
All right.
That the Ministry of Human Resources Development, Government of India, to an order dated so and so, withdrew the recognition granted to all certificates, qualifications awarded by professional bodies, institutions in the field of technical education. The MHRD further stipulated that from 1/6/2013 onwards, the courses for equivalence will cease to have effect for employment in central government, and the decision on the continuation of the certification of equivalence of degree diploma would be taken by the statutory regulator AICTE after review. That
Sorry, you're reading from which page?
Page 81. The last paragraph, page 81. It's, your lordship, it has been filed by Dr. Anil Kumar Torma.
Huh? Yeah, right. Yes.
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 Your lordship has gotten that?
Yes.
Page 81. I'll read again, your lordship.
But it is not 81, it is 239 as per this paper.
239. I apologize, your lordship. 240. And now page 240 thereafter. Paragraph number para B. That accordingly the council in its 52nd.
No, you read from para A.
Para A, your lordship, yes. That the Ministry of Human Resources Development, Government of India, through an order by so and so, dated 6/12/2012, withdrew the recognition granted to all certificates, qualifications awarded by professional bodies, institutions in the field of technical education. The MHRD further stipulated that from 1/6/2013 onwards, the courses for equivalence will cease to have effect for employment in central government, and the decision on the continuation of the certification of equivalence of degree diploma would be taken by the statutory regulator, AICTE, after review. That accordingly, the council in its 52nd emergent meeting held on 3/8/2017 decided to recognize equivalence for all purposes including higher education and employment technical courses conducted by various professional bodies, institutions which were duly recognized by MHRD with permanent recognition up to 31st of May 2013. Thus, all those students who were enrolled with these institutions with permanent recognition up to 31/5/2013 stood recognized. That's my case, Your Lordship. That is the only submission, and petition number 1 and 2, they enrolled prior to 2013 and obtained their course, respondent number 2, in the summer of 2014. The enrollment had been done prior to 31/5/2013. Your Lordship will kindly have a look at the Honorable Supreme Court's judgment and order, Your Lordship.
Where is that order referred to in clause paragraph 4A?
No, they haven't appended it, Your Lordship. But the order, the Supreme Court's order, Your Lordship, makes the stand clear.
Now, whether the permanent recognition was there up to 2013, where does one find it?
So what has happened, what the Honorable Supreme Court had held, that all the courses and degrees obtained prior to 31/5/2023, including enrollment, would stand valid. Your Lordship will kindly come to the last page of the order, Your Lordship. At para 50. Para 50, last page. In the circumstances, we do make an exception in favor of such candidates enrolled up to 31/5.
You are giving me what? Selected pages of the judgment.
I apologize, Your Lordship. I apologize, Your Lordship. I apologize. This has been an error on my part. I apologize, Your Lordship. The facts. My mistake, Your Lordship. I apologize. But
yes.
So that is the stand, Your Lordship, and the other beneficiaries of that list in 2017.
Then?
And these are the same bench that decided in the matter of Orissa lift irrigation that stated that every course obtained through a university by distant mode would stand a further scrutiny. But this is a technical institution, the same bench. In this matter, it pertains to technical institution. This is not a university.
Is there any dispute to the stand?
Yes, Your Lordship, assuming that their degree is recognized, still they have not submitted the practical courses certificate. We have clearly stated in our affidavit, paragraph 7, Your Lordship. Lordship, kindly allow me to place paragraph 7 of our affidavit, Your Lordship.
This is by
Affidavit, Lordship,
respondent number 2.
Filed by respondent number 2, Your Lordship.
Yes.
Lordship, may I read, Your Lordship? But the whole paragraph 7, Your Lordship, that with regard to the statement made in paragraph 8 of the writ petition, the deponent begs to state that the averments made in the said paragraph is not correct. In view of the objections raised by the Federation of Engineering Service Association Assam, and in view of the Honorable Supreme Court of India's judgment and order dated 3/11/2017 in Orissa Lift Organization Corporation Limited versus Ravi Shankar Patra and others reported in so and so, wherein the degree of the engineering awarded by the concerned deemed to be universities through distance education mode were recalled and treated to be cancelled, and as such the promotion of the petitioners concern are not given effect. Paragraph 59 is quoted here, Your Lordship. Thereafter, Lordship, in page number 218, 218, Your Lordship, Okay, paragraph 59 is quoted, then page 217. The candidate has as mentioned in paragraph 34 of the judgment and order dated 24/1/2020 in WPC. So that is the earlier round of litigation. Rohini, Pangsupi and others versus the state of and others. There are some requirements for a candidate to become eligible for the associate membership grade of the AMICE, one with his her name. In point number 4 and 5 of the F4 requirements are quoted below. The candidate has passed section A and B examination of the institution and has an experience of 3 years working in an organization engaged in promoting civil/architectural engineering profession. The candidate has acquired practical experience of 3 years in a manner satisfactory to the institution. In promotion planning, design, construction, maintenance, or management of such works as are comprised within profession of a civil architectural engineering or in civil architectural engineering research or teaching of engineering in a course of leading to the qualification approved by the institution. The practical training for association membership will be carried out in AICTE approved engineering college, and the practical assessment will be conducted by the concerned engineering colleges wherever the candidate is undergoing practical training. The project report for association membership is to be submitted to the principal or head of the Department of Civil Engineering or Architectural Engineering of the AICTE approved engineering college. On meeting of the requirements as above, a candidate becomes eligible for the associate membership grade of the AMCI 1 and is entitled to write AMICE 1 with his her name. Accordingly, by letter number so-and-so dated 27/5/2020, petitioners are requested to submit the details of practical experience of 3 years in a manner satisfactory to the institution. In promotion, planning, design, construction, maintenance, or management of such works as are comprised within the profession of civil engineering duly certificate by the head of the department principal of the institution wherein the practical training has been undertaken. They were also requested to submit the details of duration of the aforementioned practical training and the faculty of the institution under which the training has been undertaken. In reply, the petitioners have intimated Water Resources Department that they have done the practical training, practical experience from the institution's offices as mentioned, engage their name in following table. Table is given your lordship. From the above, it is found that none of the above mentioned organization office is an AICTE approved engineering college. As such, they are once again requested to furnish the certificate of 3 years practical training received from AICTE approved engineering college. Department has not received satisfactory reply in this regard, your lordship. Till that, they have not submitted the practical done certificate, your lordship. The department, we have already stated in last part of the paragraph, this department has repeatedly made queries to the AICTE in the matter of whether educational certificates awarded by the Institute of Civil Engineers India are valid or not, and whether the courses undertaken by the petitioner in the said institute are of distance mode or not, but no specific reply has been received from the AICTE in that. Lordship, this is the problem for us, your lordship. We could not give them promotion because till that they had not submitted the practical courses and they had not replied to that aspect of the material.
That is the ground that they have taken. The first ground that they have taken is Orissa lift irrigation. Orissa lift irrigation is not applicable in this case. The case of
That's all right, but are you required to submit your practical certificate?
we are required to submit our practical certificates, your lordship, but the fact that whether they had considered my practical certificates at one point in time or not is subject to your lordship's interference, because at page 51, your lordship will kindly come to page 51. Page 51. Our names are already recommended.
All right, what is your difficulty if you resubmit it again?
We can do that.
Why don't you do it?
We'll do it. We'll do it, Your Lordship.
Who's stopping you from doing it?
No, the fact is they've taken multiple grounds and to
Those grounds
refute those
are gone.
grounds. Yes.
Now they are saying that you have not submitted your practical certificates. Why are you referring to a 2017 position that you had submitted some practical reply
No,
thing
because
or not?
the government was
Because
ought to have-
2017,
Yes.
post 2017, there was a cloud whether these degrees are recognized or not.
No, there was a clause.
Then
Yes.
that position has been clarified.
That has been clarified. Now the only roadblock in my case is that whether I have to submit those practicals.
You submitted,
for
that
those
is
3
their
years.
ground.
We'll do that.
That's the only ground.
That's the only ground, Your Lordship.
So you submit it. Whether you should have this, if it was a part of the pleadings, we could have ordered them that these are found to be sufficient. But since they're
Since
not here,
it's not a part of the pleading.
you go and
It's not a part of
submit
the
it.
pleading. So in
Then-
fact, I had to argue the matter because there are multiple grounds taken. Now the only ground that is left, as per your lordship's determination, is the fact that I have to submit those.
No, the only ground as per their objection. If they're not raising any other objection.
Exactly. They have raised multiple objections. The only objection that probably stand the scrutiny of the lordship's law is the fact that I have to submit my practical for the past 3 years. Because
this is your only objection.
That's the
Our
only.
Lordship, that is, secondly, Lordship, in our second affidavit, we have stated that they have not taken the NOC from the department to do the regular course, Your Lordship.
NOC,
Uh,
under what
because
provision?
if they have done the
Under
regular,
what provision are you raising the objection that NOC is not taken and therefore it cannot be considered?
Lordship, in government service, Your Lordship, if anyone is going to do some course, there has to be one provision. that-
Let them furnish the NOC also. You have the NOC, one petitioner has
One
the
petitioner
NOC.
is the NOC. The other's case was already considered by the government, and assuming the other petitioner did not furnish the NOC, my humble submission, there's a judgment of this honorable court.
Then it
that
was prior.
It will not invalidate the degree. It will amount maybe to a misconduct, if at all, but it will not invalidate the degree. That has been held by this honorable court in the matter of B.A. Your Lordship.
Question, your grievance is not whether your degree is being invalidated. Your grievance is that you are not considered for promotion to the next higher post.
That, Your Lordship, that consideration is based on whether I hold the degree of equivalent of mechanical engineering or not.
Where is that issue now?
That issue does not exist. Your
Then
Lordship.
why
That
are
is-
you harping on this
No,
issue again?
that's the issue that my
No,
senior friend has raised.
they are saying that no NOC and no practical certificate.
The
You
only,
furnish all that.
the only practical certificates will be required, Your Lordship, in this regard.
You said.
Only because the NOC aspect won't come here, Your Lordship. In my humble submission.
And regarding Your Lordship, validation of the degree, Your Lordship, we have made queries with the AICC, Lordship.
Huh.
That also I could not.
Huh?
Regarding the validity of their degree, Your Lordship, we have made queries with the AICC, but we have not received the satisfactory
What is the stand
reply.
of the AICT in the affidavit?
No clear stand, Your Lordship. Only said that
No clear stand is for them to decide. But where is that minutes of the meeting? You have it?
Mr. Cal is on legs, Lordship. I will obtain instruction, Lord.
You are the counsel. You are obtaining instructions in the middle of a hearing. When were you enrolled?
I was enrolled for petitioner number 1. My course had started, Your Lordship, in 2010. And petition number 2.
When were you enrolled?
prior.
Where is the enrollment
The
certificate?
enrollment certificates are not here, Your Lordship. No, but the completion of the certificates will indicate that my enrollment was prior to that, Your Lordship.
Where is the completion certificate?
43 and 44. So I passed the threshold of 31/3/2013. Page number 43 and page number 44. These are the certificates. Page 43 indicates that my enrollment was prior to 2010, and 44 indicates it was prior to 2014.
No, the cutoff date is 2013.
31/5, 31/5/2013. That's the cutoff date, Your Lordship, has been laid down in the judgment as well as by the AICT in the affidavit.
31/5.
31/5. That was the exception which was granted to the institutions.
Section 1 of 2014.
Right, summer course completed.
True, but
Course completed.
Please come to 44.
Lordship,
44, page 44.
yes. Examination is held in summer 2014.
No, page number 44.
Yes, Your Lordship.
Yeah. See the last line, it says he has obtained a grade B in practical training. So why do you say this certificate is there? Why do you say this? He did not submit anything in the practical training or anything like that.
Page 43 also. Page 43 also.
But Your Lordship, in your affidavit, we have stated that they have given practical training from Sarva Shiksha Abhidan Mission and Water Research Department. Maybe it is not submitted, Your Lordship. I could not, because we have clear standard which they have submitted is not recognized, Your Lordship. This one is submitted, Your Lordship.
No, this is a certificate.
Huh? Lordship, yes, Lordship.
This certificate indicates that he has obtained something.
Yes, Your Lordship. Maybe they have not submitted before the department, Your Lordship, because in department they have submitted only from Sarva Shiksha and Water Research Department. From this certificate, it is also
No, I'm not on that. You see, they may have done it in Sarva Shiksha or water resources, but the fact that they have completed is indicated in the certificate. That is what I'm saying.
Yes. That I have to clarify from the department, Your Lordship, why they have stated such then, Your Lordship.
Right. You submit your work experience or what practical experiences before the authority.
I can, but with utmost humility, Your Lordship, I'll submit that the other contentions that have been raised will have to be closed because subject
Of course,
to,
we are closing it.
yes, The other objections cannot stand in the face of judgment rendered. And the NOC, Your Lordship, they'll have to, that amounts to, if at all it does, to a misconduct. It does not invalidate the degree. And they cannot discount that degree for.
Right, heard Mr. M. Sharma, learned counsel for the petitioner, Mr. M.S. R. Dekar, for Water Resources Department. Your name?
N. Kakoti, Lordship.
N. Kakoti, appearing on behalf of Mr. SCKL of the AICT.
Lordship.
There are the petitioners are serving as junior engineer civil in the Water Resources Department, Government of Assam. Stop. Both the petitioners were appointed. Both the petitioners had acquired
AMICE.
AMICE diploma. What is this diploma?
Diploma. It's
Diploma.
Yes.
From the Institution of Civil Engineers within bracket India.
India.
In what? In civil engineering?
In civil engineering, Your
In
Lordship.
civil engineering. And which, according to the petitioners, and which diploma, according to the petitioners, is equivalent to the BE degree. Stop. Petitioner number 1 joined inner services on 6/7/2010. Petitioner number 2 joined in his services on 11/7/2011. Since their respective dates of joining, petitioners have been rendering their services. Stop. It is the contention of the petitioner that they had rendered services to the satisfaction of their superior authority, and no departmental proceeding, etc., had ever been initiated against the petitioner. Stop. The petitioners submit that in terms of the service routes, they have the necessary qualifications and have also acquired the required experience for being considered for promotion to the next higher post of
Assistant
engineer,
engineer.
civil.
Yes.
Stop. It is the contention, the petitioners, that although their names were
recommended, page 51, Your Lord.
were put up for consideration, and their cases were duly considered by the selection board. They were found to be eligible and their names were recommended for being promoted to the post of assistant engineer as per Rule 11.5 of the Assam Engineering within bracket Flood Control Department bracket close service roads 1981, subject to approval of the APSC. So, subsequently, the petitioners' cases, the petitioners were not appointed in terms of the recommendation of the selection board on the ground that their diplomas were not recognized by the AICTE, which is the premier body in respect of issuing recognition and affiliations to, would like to please to my point, affiliation to various institutions who are who are imparting various degrees and diplomas in technical education. So, what is the relevance of this order here? WPC 5042? Page 62.
Page 60. Page 60, in fact, Your Lordship, this 60, please.
Annexure 9
Annexure 9. Yes, this was pertaining to the initial appointment, Your Lordship,
of,
as junior engineer in the department. Your Lordship will kindly come.
but their names are not reflected here. Who filed the petition?
No, this matter, Your Lordship, is a similar matter in another irrigation department where the promotion was stopped, withheld because of the same defect that the university had thought. So this was to draw parity with the situation.
Did you approach the court earlier for this issue?
Yes, Your Lordship. Your Lordship will kindly come to Your Lordship, page 109. Page 109. Petition number 1, name is as petition number 1, and number 7 is the petition number 2 at page 110. Page 167, Your Lordship, is the operative part, paragraph number 94, where the earlier matter was also referred to, that Your Lordship had just pointed out. As regards the contention of the petitioners that the issue raised in this petition is covered by the decision rendered by this court in WPC number 5042 of 2017, disposed of on 16/11/2017, this court is of the opinion that in view of the decision rendered by the Honorable Supreme Court in Orissa lift litigation, the matter would require to be further examined in terms of the decision of the Honorable Supreme Court as referred to above, more particularly as regards the issue of validity of a certificate, diploma, degree course offered by any technical institution through distance mode education as referred to above. In the opinion of this court, matters relating to technical education, distance education mode, and AICTE have been comprehensively and decisively dealt with by the Honorable Supreme Court in the aforesaid case, and as such, any decision rendered by this court relating to technical education, distance education mode, and AICTE are to be in tune with the said decision. And the petitioners in that case, Your Lordship, have been.
So what was the direction of the court? Yeah. Further examination.
Further examination in terms of.
All right. Being aggrieved, the two petitioners, along with other similarly situated persons, approached this court by filing WPC 889 of 2023. So, this court, by judgment and order dated
Your Lordship, direction is at page 65.
24/1/2020. After considering the matter in its entirety, including the judgment of the apex court rendered in Ulsa Lift Irrigation, reported in so and so, that disposed of the matter, that the matter will require further examination in terms of the decision of the apex court, more particular with regard to the validity of the certificate slash diploma slash degree course offered by the technical institution to distance mode education. Stop. The writ petition was accordingly disposed of. Against this was any appeal filed?
No.
Okay.
In fact, there was a review which was subsequently withdrawn by the state in the line of the judgment of the Institution of Mechanical Engineering, because at that time the order was not reviewed. Your Lordship will kindly come to page 65 for a moment. For a moment, just for clarification. Page 65, para number 7. That is what the subsequent order of this Honorable Court referred to. Paragraph number 7, page 65. Equivalence prior to 31/5/2013. Your Lordship has seen that.
When was this earlier writ petition disposed of? Which date?
The earlier this petition was disposed of in 2017.
2022.
The earlier writ.
While the matter was thus situated, the AICT held in its meeting. Where is the notification of AICT? Press release?
The press. Yes. It's a notice, Your Lordship, that the
Notice,
public.
yes. Where is it?
Yes. The notice is. It's at page 96. 96.
The AICT. What is the date of this notice?
Your Lordship, this notice date 96. Not aware of the date exactly, Your Lordship. But
meanwhile, the AICT in its 52nd emergent meeting held on August 3rd, 2017, decided to recognize the equivalence for all purposes, including higher education and employment, to technical educations conducted by various professional bodies slash institutions which were duly recognized by MHRD with permanent recognition up to 31st May 2013. It was decided that all students who were enrolled with the institutions with permanent recognition up to 31/5/2013 stood recognized. Stop. What prompted you to file the petition again, subsequent?
because I've not been promoted.
That you had already urged in the earlier petition.
Yes, in fact, Your Lordship would kindly see thereafter there was a contempt case which he had filed for non-implementation of the order. It's at page 207. page 211 is the relevant page, Your Lordship. A statement is made by the respondents in the Water Resources Department that as directed by this court in its order dated so and so, all relevant materials and documents have been forwarded by the authorities of the Water Resources Department to the AICTE, but no response is forthcoming from the AICTE. If the response is not coming from the AICTE, the remedy for the petitioners would be such, if necessary, for seeking a direction against the AICTE, but it cannot be construed that as because the AICTE is not giving its response as to why the authorities in the Water Resources Department are alleged to have willfully and deliberately violated the order of this court. We reiterate that the contempt proceeding is neither an execution proceeding nor is jurisdiction enabling litigants to wrench out any kind of favorable situation from the. So this is the background.
Pursuant to the judgment and order dated 24/1/2020 passed in WPC 889 of 2008, since the cases of the petitioners were not taken up for consideration for promotion in terms of the TPC held, which had earlier recommended the petitioners to be promoted to the next higher post of assistant engineer.
Assistant engineer. Yeah, sure.
But the petitioners filed a contempt petition, being contempt petition number 589 of 2020. Contempt case number 589 of 2020. This contempt petition came to be disposed of by order dated 14/11/2022. This court held that this court, while closing the contempt petition, permitted the petitioner to had given liberty to the petitioner again, had given liberty to the petitioner to approach again in any appropriate manner, as may be advised for furtherance of their demand. Stop. Error. Since the petitioner's cases remain undecided, in spite of directions by the court, the petitioners have approached this court by filing the present writ petition. So, two of the petitioners, right? Two of the petitioners, namely, to approach this court. What happened to the other petitioners? The petitioners have reiterated that they had duly acquired the AMICE within bracket capital I diploma in civil engineering from the Institution of Civil Engineers, India, and which is a recognized body by the AICTE, and which diploma is equivalent to the
Mechanical engineering.
Mechanical or civil?
No, civil, but it's equivalent to, it's considered as, this is what the certificate reads, Your Lordship.
Is equivalent to a BE degree in civil engineering. Stop.
Civil engineering.
And that it is the further contention of the petitioners that the certificates issued clearly reveal that the petitioners had undergone practical training / tests and project works in AICTE approved engineering institutes, and that the undergone in AICTE approved engineering, undergone what is a practical training and tests and project work in AICTE approved engineering institutions. Stop. Sorry. The petitioners therefore pray for appropriate writ direction or order, directing the respondents to promote the petitioners to the next higher post of assistant engineer. Stop. Para. The petitioner's case have been contested by the respondents by filing their respective affidavits. Stop. The Water Resources Department disputes the contentions of the writ petitioners that the that the department had already issued correspondence, had carried on correspondences with the AICT, seeking clarification whether the degree or diploma of the writ petitioners are recognized by AICT. So, it is their further case that the petitioners did not apply for NOC before proceeding to obtain their degrees. Obtain or before proceeding to pursue their uh, uh, studies and obtain the diploma. So the further ground is that the petitioners did not place before the concerned authority the relevant certificates certifying that the petitioners have successfully undergone practical training in AICTE approved institutions. Stop. The AICTE, on the other hand, has filed an affidavit reiterating their stand that in terms of the decision adopted in the
52nd emergent
meeting,
that is also given in page number 204. Yes, it's a circular.
in the 52nd emergent meeting held on 3/8/2017, it had decided to recognize equivalence for all purposes, including higher education and employment, to technical courses conducted by various professional bodies / institutions which were duly recognized by MHRD with permanent recognition up to 31st May 2013. It is contended that all those students who are enrolled in these institutions with permanent recognition up to 31/05/2013 stood recognized. The counsel for the parties have been heard. Pleadings available on record have been carefully perused. The judgment placed before the court, rendered by the apex court in Orissa Lake of Irrigation, is also carefully taken note of, as also the judgments of this court, judgment of this court rendered in WPC numbers. So, at the outset, it must be mentioned that the certificates which are available in as an annexures to the writ petition, which are furnished by both the petitioner they reflect that insofar as the writ petitioner number 1 is concerned, she had passed section capital A and capital B of associate membership examination within bracket AMICE, then another bracket Roman I bracket close square bracket in civil engineering held in winter 2010. Stop. It said certificate also certifies that the member, namely petitioner 1, had undergone practical training / tests and project work in an AICTE approved engineering institution and has attained B grade. B grade or A grade?
It's B grade.
B grade.
After section A and B, it's called B grade.
Stop. A similar certificate is also issued in favor of petitioner number 2, which certifies that the petitioner has cleared the examination in the summer of 2014. Stop. Therefore, prima facie, these certificates issued by the AICT, the Institution of Civil Engineers, reveal that both the petitioners had cleared the written examination in civil engineering and had also undergone practical training / tests and project work in an AICTE approved engineering institute and has attained B grade. Stop. These certificates are not disputed by the Water Resources Department. Stop. Furthermore, the decision of the emergent 52nd emergent meeting of the AICT held on 7th has taken a decision that the institutions which had permanent enrollment prior to 1/6/2013. 1/6/2013.
31/5. Yes. Thereafter, 31/5 is the threshold. It's a cutoff date.
Permanent registration up to 31/5/2013.
Yes, up to 31/5.
And the degrees by and the degrees conferred by such institutions are recognized. Sorry, not degrees. And the professional courses conducted by such professional bodies or institutions recognized by MHRD are recognized by the AICT. Stop. There is no averment in the affidavit in opposition filed by the AICT that the Institution of Civil Engineers which had issued the certificate in favor of the petitioner 1 and 2 by the certificates dated 15 September 2012 and 15th September 2016 were not duly registered, were not duly recognized by the MHRD with permanent recognition. Stop. Stop now. Or that their recognition at any point in time was cancelled prior to 31st of May 2013. Stop. What is also not in dispute is that this is the qualification which was required by the petitioners at the time when they entered the services under the Water Resources Department in the post of junior engineer.
Junior engineer.
Stop. What is the qualification for junior engineer?
But that I'm not aware. It is not applicable.
Stop. It is not disputed by the department that these that that the qualification which the writ petitioners have acquired through Institution of Civil Engineers is not the appropriate qualification prescribed under the rules. Stop. Rather, the minutes of the meeting of the committee held on. Where are the minute? Page number?
Page 48.
Minutes of the meeting held on
It's 27/2,
27/2,
2017.
2017. Duly recommended the writ petitioner for promotion to the next higher post. Stop. There is no reference in the minutes to suggest that the petitioners were not duly qualified in terms of the service rules for being considered for promotion to the next higher post. During the course of the hearing, the objections raised by the counsel for the Water Resources Department was to the effect that the petitioners did not furnish their practical, what is that?
Practical courses certificate.
Practical coursework certificates.
Yes, Your Lord. Certificate from practical courses from the AICT approved institute.
In which they had undergone the AICT, in which they had undergone their practical coursework from such AICT approved institution. So, the further objection is that both the petitioners did not obtain the NOC prior to completion of their prior to proceeding for continuing their studies and acquiring the diploma from Institution of Engineers. So, where is that NOC given to the petitioner number 2?
Annexure number, it's 42, page 42.
However, by communication dated 16th of March 2016, issued by the Undersecretary within bracket E to the Government of Assam Water Resources Department to the petitioner number 2, it is seen that he was issued the NOC for prosecution of degree course of Associate Member of Institution of Civil Engineers, India, AMICE, within bracket I, under the Institution of Civil Engineers, India, Ludhiana, Punjab, on the distance mode, subject to there being no impediment in the day-to-day departmental and official obligation. So, insofar as the as such, the objection that there was no objection raised for end of legor was issued to the petitioner number 2 is belied by the communication dated 16 March 2016 issued by the department. Such objection, therefore, not sustainable in respect of the petitioner number 2. So, insofar as the petitioner number 1 is concerned, it is the claim of the petitioner that she had acquired this degree for diploma.
Enroll in the degree.
She had enrolled in the diploma prior to her joining in the
Yeah.
services.
It's the government's admission also at page 49. The government is admitted to that. Page 49.
49.
Page 49. The same minutes your lordship had gone through.
Yes.
The fourth line from below, in the first paragraph.
Hmm.
Topon Kolita is the first word. Jumi Kolita, Rohini Fangsopi, so and so, had gotten admission into the degree courses before joining in this department.
You are reading from?
Yeah, I'm your lordship. 1, 2, 3, 4, 5. The fifth
Yes.
line from bottom in the first paragraph. The line starts with Topon Kolita.
Hmm.
Jumi Kolita, Srimati Rohini Fangsopi, she's a petition number 1. So and so had gotten admission into the degree courses before joining in this department as junior engineer. It is their own admission.
Which degree course?
Into the degree courses, this degree courses, your lordship, is the AMICE for the purposes of promotion to assistant engineer. So I understand that this is referring to the AMICE.
Insofar as the writ petitioner number 1 is concerned, with regard to the objection raised by the department that she did not apply for NOC, it is seen from a perusal of the minutes of the selection board held on
27/2.
27/2/2017
Yeah.
that in respect of the writ petitioner number 1 and 5 other employees, the selection committee had recorded a finding that they had got admission into the degree courses before joining in the department as junior engineer.
And Topon Kolita and Jumi Kolita had been promoted.
And all these degrees were acquired by the incumbents concerned, namely diploma in A and B of AMICE within bracket I in civil engineering from Institution of Civil Engineers India, Ludhiana, Punjab, and other technical universities. So, as such, there is a finding by the selection committee that the petitioner had enrolled for acquiring the degree/diploma from the Institution of Engineers prior to her services in the Water Resources Department. Therefore, even in case of the petitioner number 1 also, no NOC is contemplated, and the objection raised by the department, therefore, is cannot be sustained. So, what is the finding in Orissa lift?
It is in the affidavit, your lordship, paragraph number 59. By the organization. Page number 216, your lordship. But your lordship, if I may pray for one perusal of your lordship's eyes on page number 204 of the writ petition.
No, you point out from the judgment.
No, in fact, the reason this judgment is not applicable is there in page 204. Page 204. It is a circular dated 2020.
Yes.
Here it talks about the inapplicability of Orissa lift irrigation and the applicability of Institute of Mechanical Engineering. And this is by the AICT.
During the course of the hearing, it was a circular dated 23/11/2020 issued by the AICT has been referred to by the counsel to the petitioner. So the said circular reiterates the decision of the AICT taken in its 52nd Emergent Council meeting held on 03/08/2017 that courses conducted by professional bodies / institutions in accordance with MHRDOM number 11-15/2011-AR dated 6/12/2012 for equivalence for all purposes, including higher education and employment, which were duly recognized by MHRD with permanent recognition up to 31/05/2013. Accordingly, students who were enrolled in these institutions as per the above MHRDOM with permanent recognition up to 31/05/2013 and had obtained their degrees or diplomas. Such degrees or diplomas are recognized and to that effect a public notice dated 31/10/2017 was issued. Stop. Under such circumstances, this court finds that the objections raised by the respondents, insofar as the petitioners are concerned, for considering their cases for promotion to the next higher post, have already been clarified by the AICT by its meeting held on emergent meeting held on so and the notice published by the notice dated so and so. Stop. Under such circumstance, this court is constrained to direct the respondent to place the cases of the writ petitioner before a review selection board to reconsider their promotion to the next higher post. With effect from the date their juniors were promoted and they were found to be eligible for promotion, subject to they being found eligible to be promoted uh, uh, on a date when their juniors were promoted.
2017.
However, considering that the department has raised objections that the petitioners did not place the certificates or uh, did not place the certificates for their practical projects undertaken from the AICT recommended institutes. This court directs the respondents, directs the petitioners to place such certificates within
2 weeks or one, I'll leave it to your order. 2 weeks.
within 3 weeks from the date of receipt of a certified copy of this order. So, on such certificate being placed, the department will carry out the directions contained in the order by placing their names before the review selection board for being considered for promotion to the next higher post. With effect from the date, the juniors of the writ petitioners stood promoted. So, with this exercise will be carried out within a further period of 6 weeks, 8 weeks, 3 months, 3 months, 90 days from the date the petitioner furnishes the certificates as directed. Writ petition disposed of in terms of the above directions.
If I may pray for one clarification, my promotion not to be from the date of my juniors, but from the members in the notification dated 1/8/2007. That is all. 1/8/2017, page 51 to 50.
Right, with effect from the date, the notification dated. No, what happened to the other writ petitioners? That's what I was asking you. In the notification, there are so many persons' names.
Yes, and most of them have been promoted also in 2017.
So, are they seniors or juniors?
So that is, in fact, so the gradation list, so this is also as per the roster point also.
This must be as per the gradation list.
This is as per the gradation list, and the final recommendation of 12 names is as per the roster points, Your Lordship. So the entire chronology of the list is not. So the entire chronology of the gradation list will not be followed because the roster point is followed here. So
All right.
my prayer would be that
in terms of the notification, with effect from the date,
yes,
the notification dated 1/8/2017 was published. You find out what is the position there. Writ petition disposed of.
I'm grateful.
Wait, cases are lordship, my lord.
29 to give. Already one file is not here. 31.
31 and 32 both, my lord. 31 may be taken up, my lord. Here, lordship may taken up this matter finally for disposal, my lord, on Thursday, because he is also not present. But matter is very simple otherwise.
Lordship.
He is here, my lord. My lord.
Here, Lordship, they were asked to appear before the committee, Lordship, on 21st of this month, Lordship. And yesterday, Lordship, the petitioner in both the matters have been terminated. Their service has been terminated, Lordship.
You have seen it?
I have not. I am shocked, my lord. My lord, here, my lord, my case was that, my lord, non-payment of
He
salary.
has ensured that you don't survive to fight for another day.
No,
By
for the
protesting.
days I work, my lord, I am entitled for salary, my lord.
Whatever it is, this order is there, you go through. If you think
That's correct, my lord. I will challenge. Because let it be pending, my lord. I will challenge that.
you
both may
challenge
be-
it, why this is required now?
No, it is required, my lord,
Why?
because salary was stopped, my lord, from October 2023, my lord, till date. So in that view, my lord, even if they terminate, my lord, they accept, my lord, acknowledge
32.
here in this petition by the document, I was working, my lord, and page 38.
32 too.
Copy এটা দিয়া, দুইটারে এটা এটা দিয়া।
You are terminated.
My
You are
termination.
you are praying for release of your salary.
Yes.
But meanwhile, you have been terminated. So
Mala, we have not been served with the copy, my lord, perhaps.
heard Mr. B.K.
Like
Das,
yesterday.
learned counsel for the petitioner, from Mr. D. Upamanu for the health department. It is submitted that during the pendency of the writ petition, the petitioners,
Inquiry
this is pursuant to some inquiry.
Yes, Lord.
My lord, inquiry notice was issued. My lord, no inquiry report, nothing, no examination, we'll challenge that, my lord.
You challenge it. But
Yes, ma'am.
there is no interim order here, isn't it?
No, no.
No.
Because there is no question of challenging the proceedings here. You are only prayed for
Yes, yes.
salary.
Salary, my lord. I will
During
challenge
the
the separately. my lord.
pendency of the writ petition filed by the writ petitioners, praying for release of their arrear salary, the departmental proceeding which was initiated stood concluded, and thereafter by speaking order dated 26th of March 2025, the petitioners were terminated from their services as vaccinated with immediate effect. So these orders were, the counsel for the petitioner submits that he has just been served copy of the said order.
Not been
Accordingly,
served, my lord, let him serve, my
Yes,
lord.
Lordship, I'll provide, Lordship.
Yes.
all right. He
Already,
submits
Lordship,
that copies of the orders have not been served on him. Counsel for the health submits that the writ petitioners have been served with copies.
Yes, Lordship. The person concerned has been served. Lordship.
Accordingly, this court considers it appropriate to defer this matter for 2 weeks.
My
Highly obliged, Lordship.
obliged.
Your lordship already heard, your lordship. Both sides have argued, your lordship. Last occasion, your lordship, two judgments are shown by learned government advocate, your lordship, PC Sutia, your lordship. One ECIL, your lordship, and your lordship, another one is from relating to personal hearing, your lordship.
Your grievance is that you are not considered for promotion.
Then, your lordship, I have finally.
Which they submit is that because this is because during the currency of the
Lordship.
punishment.
Then, your lordship, after your lordship, there another ground, your lordship, of not furnishing the copy of the opinion of the APS, your lordship. That, your lordship, I have submitted two judgments, your lordship. One by the Honorable Apex Court, one by our High Court.
Narula.
Your lordship. Now, your lordship, subsequent to that, your lordship, two judgments are furnished by PC Sutia, your lordship, Learned State Council. One ECIL, your lordship. My submission will be on ECIL that there is don't have anything to do with my case ECIL. ECIL essentially is a case where inquiry report whether to be mandatorily given to the
This is under discipline and service appeal.
Lord.
The part of the route only.
Lordship, that's what. And in my case, your lordship, and furnish it.
Agreed by APSC report.
Lordship.
But the inquiry report was submitted.
No, there is no inquiry at all. Since your lordship, it was a minor punishment, and then your lordship, I admitted the charges. Therefore, your lordship, they instantly punished me, your lordship.
Yes.
Then, your lordship,
I took two grounds, Your Lordship. Firstly, that Your Lordship, there are two punishment, Your Lordship. One deprive him from Your Lordship promotion, and the other one is Your Lordship increment was Your Lordship reduced for 1 year, Your Lordship. Now she furnished two judgments of the Honorable Apex Court, and after going through some other judgments, I found that that ground will not sustain. And second ground, Your Lordship, therefore I argued, Your Lordship, on that furnishing of opinion of the APSC. And second judgment PC Suti has shown this to Honorable Court is relating to personal hearing, Your Lordship. My case is not about personal hearing. This Punjab case is about giving personal hearing at the review stage, Your Lordship. Whether it is to be given or not. That is, Your Lordship will find 2007 8 SCC 108.
Nirmal Singh.
Lordship, Nirmal Singh. And I am not claiming any personal right to personal hearing. Your Lordship. My only grievance is therefore is that
You were not served with an inquiry report.
Not inquiry report, but the opinion of the.
No, that is what we say.
Lord.
Only you are aggrieved that opinion is not
furnished.
Furnished.
And if
how does it effectively prejudice you?
It prejudices me, Your Lordship, for two reasons. Your
This is
Lordship.
only a question of approval.
No, not approval. That's what Your Lordship. Approval, had it been a case of.
Where is the APSC recommendation?
Lordship, Your Lordship will kindly see the discipline and appeal rules for a moment.
No, no. Where is the APSC government advocate? Where is the APSC recommendation or approval?
They say in the affidavit that they have sent it through APSC approved it. But Your Lordship, rule says, Your Lordship,
Yes, rule.
Discipline and appeal rules. Your Lordship, 10. And 11, Your Lordship, minor penalties. If the disciplinary authority, having regard to its finding on the charges, is of the opinion that any of the penalties specified in clause 1 to 3 of Rule 7 should be imposed, itself pass appropriate orders, and in every case in which it is necessary to consult the commission, shall do so after consulting the commission. After consulting the commission, they will have to impose the penalty. Now, here is a case, Your Lordship, they send it to the commission and commission approve it, Your Lordship. That's not what, Your Lordship. They already have taken a decision that then they send it to the commission. But rule says, Your Lordship, after
the difference.
Difference because
the meaning of consulting?
No, Your Lordship, after sending it to the APSC, Your Lordship, if APSC will give an opinion, Your Lordship, based on that opinion may be different.
No, but is it your case that opinion contrary to the conclusion has been given by APSC?
No, Your Lordship, I don't know because Your Lordship opinion has not been furnished to me.
Where is that opinion of the APSC?
Lordship, that is not brought on record. Lordship. That is not brought on record, Lordship.
You don't have to bring it on record. It's there in the record. To the court will have it. If it is there.
The record is not here with me.
Get that part of the record which contains the.
Lordship, in our affidavit in opposition at paragraph 7, Lordship, that with regard to statements made in paragraph 18 of the writ petition, the deponent category denies that the additional chief secretary to the government of Assam personally department passed the award of penalty of stoppage of 1 annual increment in violation of established rules and procedures of departmental proceeding. The deponent states that the disciplinary authority in excess of powers under sub-rule 4 of Rule 9 of Assam Service Discipline and Appeal Rules 1964 examined the reply of the petitioner dated 25/5/2015 and found that Lordship has found it.
2, 3, and 4
Paragraph 7, Lordship,
of the
of the affidavit in opposition.
respondents 2, 3, and 4.
Lordship,
There are 7.
7.
Yes.
The deponent categorically denies that the additional chief secretary to the Government of Assam Personal Aid Department passed the award of penalty of stoppage of one annual increment in violation of the established rules and procedure of departmental proceeding. The deponent states that the disciplinary authority in exercise of powers under Sub-Rule 4 of Rule 9 of Assam Services Discipline and Appeal Rules 1964 examined the reply of the petitioner dated 25/5/2015 and found that the charged officer had admitted the charge and hence further inquiry on the matter was not necessary. In his reply dated 25/2015 to the show cause notice, he admitted his misconduct in clear terms. As the charge was admitted, the disciplinary authority imposed a minor penalty of stoppage of one annual increment upon the petitioner in consultation with the Assam Public Service Commission as required under Sub-Rule
What we
11.
want to see the consultation. Where is the consultation?
Lordship, Lordship may grant me some time to get the opinion
Get the
right.
consultation, we'll see. You'll have to satisfy us that you have been prejudiced.
No, Your Worship, so far as prejudice is concerned, Your Worship, for giving an effective representation to the punishment, Your Worship, there may be punishment, Your Worship, 2 punishments is there, Your Worship.
Lordship, I have already submitted judgments.
We'll have to first, what? The punishment is given by the department.
Lordship.
By APSC.
Lordship.
APSC consultation.
In consultation.
Well, or confirmation, not even confirmation. Where consultation is there, as per the rule. So therefore, they may have given some consultation, yes or no, or agreed or something.
Your Lordship, it is not about the consultation, Your Lordship. It's also about, Your Lordship, opinion, Your Lordship.
Where is the opinion?
Lordship will kindly see.
11.
APSC gives an opinion, Your Lordship. Based on that, Your Lordship.
No, where opinion? Read it. 11.
No, that's Your Lordship, what Your Lordship. Nerula judgment and our High Court judgment has, Your Lordship.
We are,
Your Lordship may
we
kindly
have
see other
first- we
judgment.
have to first refer to the rules.
Lordship.
The opinion is of the disciplinary authority.
Lordship.
But it shall pass appropriate orders and where required, consultation with the commission.
Lordship.
That's all. The commission is not give an opinion.
No, it's consultation is mandatory, Your Lordship. That's but whatever it is.
And that has to be
That's why, Your Lordship, that opinion, the other judgment of our High Court, Your Lordship, may kindly see.
Sure, Lordship.
And in why is APSC necessary in your case?
Lordship will kindly see.
Were you selected by the APSC?
Yes, sir. Yes, yes.
Process is through the APSC.
APS. Yes, yes, Your Lordship. আমার একটু জাজমেন্ট করবো আমার হাই কোর্ট আছে Para 20, Your Lordship.
Oh.
Of the 2019, Your Lordship, 6 GL 559. That has already been permitted. 19 and 20. 20, Your Lordship.
Paragraph?
Paragraph. It is written.
22.
Lordship, 22.
Yes.
In case of Narula, the apex court has held that principle of naturality in that case is violated as the appellant was not communicated the APSC report so as to enable the appellant an opportunity to make effective representation in quantum of punishment prior to imposition of punishment. Para 20 also.
Where is Gunakanto Tamuli? Is it there?
Para 20 also, Your Lordship may kindly peruse. Based on these, your lordship, 2021, then your lordship. Here also, your lordship, it was a minor penalty, your lordship. If it is on the
Yes, just say in the advisory opinion is to be part. You get that opinion better. Get that. Counsel for the respondent will furnish the relevant report containing the opinion of the APSC. In respect of the conclusions arrived at by the disciplinary authority insofar as the departmental proceeding of the writ petition is concerned. Mr. S. Bothakur appears for the petitioner, Mr. S. K. Medi for Accountant General, Mr. U. Sharma for the state. List after
1 week, Lordship.
1 week. After 1 week.
obliged.
10:35.
It's your 34. দেও তো ভয় রেখে পড়ে কি Yes, just 1 minute. Yes.
First counsel is appearing through TC.
No, I know, but what I want to say is that it's been quite some time now.
Yes,
Why I'll release it from part heard. You argue the matter before appropriate time.
My lord, the senior counsel would like to appear physically if 24th April may be given of the board. I understand, my lords, quite some time has elapsed.
24th April is not convenient. You can have it on 22nd if you want.
And please, my lords, he wants to come physical, my lords. He is available
No,
on
24th is not convenient for this. That's what we say.
My lords may allow the VCL link.
Or you have it on 29th or some other date.
My lords may give the VCL link, let the senior counsel himself present, because even I am not aware of the dates.
You talk to him and inform the court master.
My lords.
Do it. We'll have it on 29th or something for final hearing or whatever else is to be done. 29th or 1st of May.
My lords, I will.
You talk to him just now and let us know. Yes.
Interim orders to continue, my lord.
No. You inform the court master. We have not
No,
passed the
sorry.
order. We are just giving you the opportunity to
coordinate,
to find out what dates are convenient
Obliged.
as per his calendar, and inform the court master. Yes.
Well, we'll fix the matter on a hearing day after the vacation, my lord. Now it's a departmental proceeding, my lord. Penalty has been challenged. It will not be over even if I start.
He is that complicated.
Little bit complication is there, my lord. Records your lordship has asked to produce.
After the vacations,
A
after
date?
2 weeks.
Yes, sir. A date may be fixed.
Date will be fixed by the registry. This is a hearing matter. These are hearing matters. It will be
Any
fixed by the
Tuesday, my
registry.
lord, it will be convenient if can be.
No, we see. Then let us have it in May.
Fine, my lord.
For 2016 matter.
It's a bit old, my lord. Can it be on, my lord, older?
1st of May. 1st of May.
1st of May. Or 6th of May, my lord.
6th of May. All right.
Fine, my
Mr. Borua
my lord.
has agreed to list on 6th of May for hearing.
Highly okay.
For 36 and 37, I appeared and my friends appeared for the other 5 items.
Lordship, for NRC Lordship, this Mr. Zepaying is unable today, Lordship.
What is the issue here? What are you challenging?
We are challenging termination order. The scheme is running. Some of the employees
Termination of what?
Termination of our engagement. Lord. We are engaged by a statutory regulation. The statutory regulation provides a method.
You're serving where?
NRC, that NRC process. Lord.
NRC.
NRC, where some of them are junior assistants, some of them are circle project managers and grade 4 employees. All of them are terminated, keeping some. The scheme is alive, but we are out in violation of the service regulations.
Pleadings are completed.
Pleadings are complete.
Get a date. Yes, madam. When is your senior available?
24th April.
24th of April.
24th of April.
Yes.
All right, list on 24th of April.
Deeply up.
As agreed to by the
28th is
council
an
for the party.
interim order to continue.
Interim orders passed earlier will continue.
Deeply obliged.
Item 41.
May I please, your lordship? Lordship, 2 weeks time may be given for hearing, lordship, because our senior was there few minutes before he has left the court because he is not feeling well, lordship. So he's
Matter be listed after 3 weeks. At the request
2
made
weeks,
on
lordship.
behalf
and
of the
he's-
of behalf of
A date may be fixed, lordship.
RC, so yeah. It is.
A date, kindly a date may be fixed, lordship.
No date is fixed today. In the list, see. It'll come up on its own after 3 weeks.
Lordship.
All right?
Okay. Obliged, lordship.
43.
Doctor,
yes.
This matter needs substantial time for hearing, around approximately an hour, Your Lordship. Today it was fixed, but unfortunately, I had a discussion with the learned senior advocate. Your Lordship can give us.
Yes.
After view.
It has to be after view only.
6th, 8th or 13th, Your Lordship?
29th
8th or 13th, 6th of May, 8th of May, or 13th of May?
6th of May. 6th of May.
Well,
Item. The counsel for the parties submit that the matter will require some hearing. Because of paucity of time, the matter stands referred to be listed on 6th of May as agreed to by counsel for the parties. Yes. Yes.
Lordship recollects, my lord, on the last occasion.
Some documents.
No, he had
some claims.
Some claims, my lord. But I've taken my instructions, my lord. So far as salary and medical reimbursement is concerned, they are saying that nothing is due. But the gratuity and leave encashment is there, which we are undertaking to pay by April month.
Regarding the claims with respect to the medical bill reimbursement, can we pass an order since they have already said that those are already clear? Grateful if this honorable court pass an order that concerned officer of respondent number 2 will give the details when they have they release those amount by which
share
form?
the details when you have.
Share it, man.
Can you
Why have you not done it?
Lordship, can you pass an order, written order? Otherwise, they will.
Why don't you share the details of what payments you have made? What is the difficulty? These
share it,
are not cash transactions.
No.
Then
everything will be
you
done.
share the details. Mr. Petitioner, Mr. Avinash Bora, the petitioner in person appears, and Mr. N. Deka, learned counsel appearing for the NRL. And
Lordship for a respondent 456. D. Mohanto.
MS, your name?
D. Mohanto.
B. Mohanto.
D. Lordship. D.
D.
Diksha. D.
Mohanto appears for respondent 4, 5, and 6. In terms of the earlier order dated 13/3/2025, Mr. Deka was the petitioner in person was permitted to serve a copy of the representation filed before the company for specifying the dues that were stated to be payable to him. Stop. Mr. Deka on instruction submits that dues pertaining to medical
reimbursement and salary.
Medical reimbursement and salary as found due to be payable to the petitioner have already been released. However, the amount pertaining to
gratuity and leave encashment.
Gratuity and leave encashment has not yet been released, but the NRL is processing the same and is likely to be released within April 2025. Stop. Mr. Bora, petitioner in person, on the other hand, submits that the particulars of the payments made in respect of medical reimbursement and gratuity,
the salary
may be furnished, indicating the dates on which these payments were made. Stop. Mr. Deka submits that the same can be furnished within a period of 2 weeks.
2 weeks.
Kindly mention that the representation dated 06/02/2025 that I have already filed to the
First,
company.
you receive the particulars of what you have received. Only then you can come and say that according to you, this is the amount, according to them, that is the amount, this is the dispute, isn't it?
Lordship, I have already submitted whatever pending dues are yet to be released by them. But
Where is that representation?
yes, already copy of the same order already up to them.
You have given the details of the payments
Yes,
payable.
yes,
It's there, Mr. Deka? Not
He is referring to pages of the writ petition, man.
Yes, Lord. I have mentioned that points are mentioned.
Utmost respect, my lord, let it be that we'll share the details of what he has paid. If he is disputing that, let him come up, my lord.
What has happened is, what should not happen is that you are giving particulars of payments, but these payments may be collective payments made at one time. Then it becomes difficult for him to, or the
We'll
court
give
to
the details,
understand.
my lord.
You give
We'll
the
give the
details.
details. We'll give the details.
Supposing you are releasing an amount, you give whether it is pertaining to one claim or 5 claims or 10
Yes.
claims, right?
We'll do that.
Can you mention in the order that in return mail they will give the details as claimed by the petitioner by the representation that
The counsel for the NRL will furnish
sponsor official
particulars of the payments made along with the amounts to the petitioner by an email.
yes,
by
return
Share it by email by the next date. By the next date of listing. Accordingly, matter deferred to be listed after
the Bihu vacation.
after 3 weeks. After 3 weeks?
Yes, can you mention in the order that that I claim recently by the representation dated 6/02/2024?
Where is that representation?
Lordship has said that he has served me with a copy of that representation. It is that representation. So Lordship may mention the date.
Indicated there?
It is there. It is not indicated, my lord. He is saying he wants the date to be reflected. Let the date be reflected.
Right. About they will furnish particulars of the payment and the amount paid, which the petitioner claimed he has indicated, which amounts the petitioner claims he is entitled to in his representation dated
6/2/25.
6/2/2025, addressed to the NRL authority. It is accordingly after 3 weeks. Yes.
All
right.
Yes.
The Lordship may take it up on 29th.
No, not in April. It goes to May.
29th, Your Lordship.
29th of May.
April, Your Lordship.
No, not April. You have to get a date in May. We'll fix it on 8th of May.
Lordship.
8th of May.
Lordship. He'll be out of India during the month of May, Lordship. This is the difficulty.
Let it be on 1st of May.
Lordship, they may be asked to submit written argument because maintainability of the written is there.
Therefore, he has to argue.
Or they can submit written argument, Lordship.
No, written argument is
Because every
not
time
available on 1st of May.
No, from 1st of May onwards, he'll not be here.
We don't know because fixing a date we can't guarantee because there are other matters fixed on 29th. All right, as agreed to Mr. KL.
Not
29th we are fixing it. If possible, we'll take it up. 29th, as requested by the council for the party, matter be listed on 29th.
Interim order may continue.
Because of paucity of time, it will not be taken up. As agreed to, it's on 29th.
Interim order may continue. Your Lord.
Interim order passed earlier will continue till the next date. Yes? 29.
Highly obliged.
Yes.
My lord. Today almost time is over, my lord. In this case, I am leading by senior counsel K.N. Choudhury, my lord. I am praying for short date, my lord. On 8th, my lord. There is some urgency matter related to the suspension, my lord.
On
8th, my lord. Next week. First week.
8th of
There
May.
is- My lord.
8th of May.
No, my lord. April, my lord. Why there is some urgency, my lord, matter relating to the suspension, my lord.
He
And
has
due to the
retired.
suspension, my lord, he is depriving from
He's
the pensionary
retired.
benefit.
He's retired or what?
Retired, my lord, but due to this case, my lord, he depriving from the pensionary benefit. That's why some
Is he getting some pension?
No, my lord, no, my lord.
No pension,
No pension. That is
no provisional pension.
Lordship, actually, that part I'm not aware properly. As per my information, no pension is there.
Not on 8th of April. It's not-
Retired maybe last month, my lord.
No.
As per my information, there is no pension, my lord. That's why there is some urgency.
My lord, there is criminal charges against him, my lord. Proceeding section has been given.
My lord, on the hearing day, we will argue on merit, my
On
lord.
1st of May.
My lord, not May, my lord. If possible, my lord.
Not possible.
Immediately after reopening of the,
On 1st of May.
my lord.
Matter
After 3 weeks, my lord, 2 weeks, 3 weeks, not, need not 3 weeks. After 2 weeks, my lord.
By the council. 1st of May. If you don't want a date, we can defer it after 2 weeks. If you
After
want
2
a
weeks,
date-
my lord. After 2 weeks.
All right, after 2